guys have water up there? Yeah. Good? Okay.
I guess
Yeah, we could wait a few more minutes. Like 5 minutes. Yeah. And then we'll just do the grand entrance whenever he gets here. Atlanta traffic is. Have these 10, 5, and 1 in that solid. Oh, perfect. How you doing? No, you're all good, all good. All right. Testing. Okay, good morning. So thank you for being here while the rest of the lazy registrants are still sleeping in. So some will continue to trickle in. Welcome to the Corporate IP Institute. This is the 18th year, and we're going to say some more kind of introductory and welcome remarks a little later on. So I just want to go ahead and jump in. So this is our first panel, and I'll try to just say a few words about the moderators, and I'll let them introduce their own folks. But Dustin Weeks is a good friend of mine, and I've known him for a long time. We had started working together in my old life when I was at Georgia Tech in the tech transfer group over there. And Dustin Weeks is a very experienced IP attorney and patent prosecutor. And he saved my life once, which was exactly 3 weeks ago when he agreed to do this panel. So you can thank him for this CLE credit, which technically I should say we are still applying for. All right, Dustin, go ahead.
Thanks, Kenny. Good morning, everyone. I'm Dustin Weeks. As Kenny said, I'm a IP attorney at Troutman Pepper Locke here in Atlanta. And thanks for attending this first session, couples therapy, corporate university partnerships, and an evolving funding climate. So this panel is really going to be about just exploring how two partners with different objectives and different missions can still build strong, productive relationships. As you can imagine, in any partnership, there's always going to be tension. In these types of relationships, you have one party that's always pushing to publish data. Another party, well, they want to keep everything confidential. One party is concerned with, what kind of royalty rates are they going to have to pay, while the other party is more concerned with what's my overall risk. So a goal is to kind of talk about these issues and unpack all that to see how, partners can work together to find common ground. Fortunately, we're joined by three experts that do this every day. We have Timothy Garrett, Justin Barnes, and Chase McCollum, and I'm going to let them kind of give you a little background on who they are and what they do.
Thanks, Dustin. My name's Tim Garrett. I am the Associate Director of Contracts in the Office of Sponsored Programs here at Georgia State. I have been doing this almost 10 years. I started at Georgia Tech, at the Georgia Tech Research Corporation, where I met Kenny, and I am from Charleston, sort of. I went to law school in Charleston, South Carolina, and where I practiced before I moved to Atlanta and got into university contracts. My prior career was a TV news reporter, so completely out of left field. And I guess that's really it.
Hey, good morning. I'm Justin Burns. I'm the Vice President for Innovation and Entrepreneurship at the Georgia Research Alliance. So full disclosure, I'm not an attorney. Sometimes I have to play one at work. Our role here in Georgia is we're a nonprofit. We're funded by the state, but our job is to put money into what we call technology-based economic development, among other things. And so we're charged to find those nuggets of technology that really have commercial potential and sort of fund them beyond what basic science funding can do. Look for ways to bring the technology, the science from the lab to the marketplace. My background is a scientist by training, PhD in molecular and microbiology. I left the bench and worked at Emory's tech licensing office for about 10 years. I left there and went to the darker side of science to venture capital in a firm based in Boston. Ran a deal sheet there for quite some time on the buy side, mainly in life sciences, but did a little bit of everything under that umbrella, so digital health, drug discovery, pharma, as well as shrimp farming and a few other different things. So have been on both sides of the transaction. And so we really like to invest, across the spectrum. So as early as, back of the envelope type calculations, want to make sure that there's a solid IP foundation, making sure that we set the projects and companies up for success. And then we also invest in the companies that come out of those labs here in Georgia. So we love to see things grow and be happy to contribute here.
Hello, my name is Chase McCollum. I work at Georgia Tech. I'm a contracting officer there. I negotiate sponsored research agreements, particularly with industry sponsors. I've been at Georgia Tech for about 5 years. Once upon a time, I went to law school at the University of Georgia. So I should reiterate, the views and opinions expressed here do not necessarily reflect those of my employer, in case a Go Dog slips out. I'm excited to talk about kind of, I'm often negotiating with people on the other side of the table who have different experiences than mine, but it's always a fun opportunity at a place like this to kind of come together and see, in a more troubleshooting capacity of how can we make this work better for everybody.
Great, and we have Chase and Tim both from the university side that can provide a lot of perspective on what the university's thinking in these negotiations, whereas Justin has kind of steps on the outside and watches all of these collaborations come together. So he's great at providing insight into what both parties see as issues and trying to make these work. And also what makes them break down over time too. So maybe let's start out by just talking about the foundation of it all. When university and corporations or industry, when they come together, what are they generally looking to achieve, and how do they measure success in those relationships?
I mean, Chase and I do a lot of the same thing, so I don't want to, I'll let you start, and then I'll just kind of piggyback off whatever.
Sure. I mean, this is, a pretty introductory question to the conversation, but it's also one that runs throughout our negotiations in a pretty deep way. Because I think that a lot of our sponsors, particularly the industry sponsors, are expecting that this is the kind of business-to-business transaction that they're used to. Maybe even, expecting some kind of work-for-hire arrangement. They're expecting that, they are making a purchase. And our interests are not necessarily in that vein. We are a nonprofit. Georgia Tech has it structured such that the Georgia Tech Research Corporation does its contracting. And so we are a nonprofit supporting organization of a state instrumentality of Georgia. So what that means is we're not necessarily engaged in the same kind of commerce, in the same kind of industry marketplace as some of our sponsors are. So our interests fundamentally are not aligned. And so it is kind of how do we get to where we're all getting something out of an agreement where we're coming from two very fundamentally different paradigms. And I think that the answer there is that we all have an interest in developing technology and that technology being put to use. So, our success looks like when we are able to advance scientific knowledge and education and everything, and then share that with the public, which includes an industry sponsor. Or maybe it includes other scholars or whoever can use it, that's what we want.
Yeah, so I was talking with a couple of folks before this, and was just coincidentally, someone mentioned the idea that it's kind of like a marriage, because we were talking about, there was, one of the attorneys he works for a firm that was talking about how difficult it can get when you have competing interests in the IP, when it comes to intellectual property and royalties and who gets what. And I told them that, I'm fortunate. I was a litigator, but I'm fortunate now that it's not an adversarial relationship at the beginning. And a lady said, it's kind of like a marriage. You both have mutual interests. You want the research. You want to do something for the greater good, and it's all copacetic in the beginning. And then once something comes out of it, and there's money at stake, that's when it gets crazy. And my job and Chase's job at the early stages is to sort of help make that, make it as get it all on the table in the beginning so that everybody's aware of what they're going into, and there are no surprises. There are always going to be surprises. We can't cover everything, but I dealt for many years with small businesses, and they're some of the hardest because you have some people who are very smart in their discipline, but they have zero, they'll just sign a contract. They don't care, they just want to get started. They want the money, and and I don't know if you were familiar with the SBIR and STTR program, but it's a great way to fund your small business because there's not a lot of expectations. There's not a lot of return expected on the idea. And so a lot of small businesses will apply for these grants to kind of help float them. sometimes they know there's not, the chance of anything materializing out of it is low. But then something happens and they start seeing the potential for it, and then it gets hairy. And so, just having to walk these small businesses through, and they're not, they don't have the resources to have general counsel or outside counsel. So sometimes they're a staff of one. Sometimes I think the max is 500 employees. So, but very rarely do you have that many, or have a business with that many employees. So they're just kind of, what do you call it? It's when you have just a, they're not working with a lot. And so they're willing to enter into these contracts without, and as the people who do this every day, it becomes sort of it's not our responsibility, but there's an ethical and a, at least from the, when we're dealing with the federal component, there's an expectation that, we can't sit back and say, well, we're not the small business, we're not the one that ones that receive the money, so it's not really, we're the subcontractor. But then but it is sort of, the onus is on us because we are the experts, allegedly, in this field. And so the expectation is that we'll help the small business. But then there's that fine line, because when it starts getting adversarial at the end, it's like, well, it puts us in a really tough spot. So those are just I mean, I could talk all day about it, but those are just some of the situations that we encountered.
So maybe I'll chime in and just sort of say, I think in any event, businesses have an opportunity to protect value for shareholders. Universities have a mission to disseminate knowledge. So Chase said it, I think you're not always directly aligned, but I think you can align on sort of what the intended outcome should be. So as the two parties come together before red lines, before contracts, find that scope of work, find exactly sort of what success looks like for both parties, especially as it relates to the work that's actually going to be done. It's not necessarily in who owns the IP, who owns, the output, what licenses are built in, but you've got to figure out exactly what's going to be done, right? You have a sponsor putting in resources, whether that's financial, whether they're providing a device to do a trial, and you have the university who wants to do this for public good, for public dissemination of knowledge, to advance technology in a certain sector. So I think alignment there is really helpful, and that's sort of where it can go off the rails even before you really even get started. Second to that is sort of then, what do the metrics look like? How are we going to sort of frame this? How do we make sure that we don't run into these pitfalls, when there is money, right? So if something is really, well studied and comes out looking like a great potential, the company's going to want to make sure they have rights to it, right? They funded the work. And then there's some misalignment on, hey, we paid for this. Well, no, you really didn't. You paid to get it done, and the university had some in-kind resources as well. So I think aligning the scopes of work, aligning those expectations and sort of what success looks like is a great starting point before a template comes out, before anything comes out, related to the paper. So I would say that's the best way to go forward.
So, touching on a few things, like Chase, you mentioned that, this isn't your typical business-to-business transaction. And, Justin, you mentioned how there's like competing interests to some extent. So early on, and Tim, you mentioned early, people are, it's a happy marriage to begin with, right? But what do you find are kind of the common points of friction when these parties are getting together early on and to kind of starting out in the negotiations and setting the tone for this relationship?
I think, at least from my time in tech transfer and time on the VC side, there is a fundamental education that has to happen. Companies don't understand what it's like to necessarily work with a university. There's different rules at the university, there's bureaucracy, there's other things, and speed is often an issue. And so I think some of that is an education component. The companies just don't understand what it is to do. There's certain things on the university side, they're just a third rail. You can't touch them. And you're going to lose and waste a lot of time trying to negotiate those points if it's really not going to happen. So that's the biggest sticking point I've always seen.
I completely agree that it's the third rail. A lot of our positions in our negotiations are dictated by our position as a public university, the state of Georgia, the fact that we do a lot of federal work, sometimes carries over and has to apply to our industry sponsors as well. And so a lot of times the company doesn't understand, well, why do I have to agree that, I'm going to comply with this or that federal rule? And I'm like, well, because we have to treat everyone even-handedly. So now I'm engaged in, well, let me walk you through from step one, how we arrived at the legal framework that we find ourselves in. And so I would say a big part of my job is just that, education. Kind of walking through, not only is this what it's like to contract with a university, but specifically a university in Georgia, and then more specifically, a public university in Georgia, and then more specifically, Georgia Tech. So even sometimes companies that do a lot of work with universities, they're like, well, MIT said we could do this, and I'm like, well, that's not us, and here's why.
Yeah, so I've had the benefit of working outside the university system of Georgia. I worked during COVID. I lived in Atlanta, but I worked for the University of Colorado Boulder, and did the same thing. And it was interesting. I wouldn't encourage people to job hop, but sometimes that's how I got to a director level is hopscotching around, and that was just my journey. But it did benefit me in the sense that I got an outside perspective. So, and what's really interesting, I never would have expected this, just because it's a big world out there, and I just never thought that it would be as siloed, but they tend to, CU does a lot of work with companies on the West Coast. And I guess it makes sense because of their geographical location. I'm just thinking they're tech companies and they're federal contractors and whatnot all over the country. And but they do, Georgia universities most often do work with a certain type of company and a certain location, and then CU does it. But all that aside, they have different thresholds on what they're willing to accept. I know like indemnification clauses, like if you're a Georgia university, we're considered a state agency. And even though we're contracting through a supporting organization, the idea is that the work is done by the university employees. We're using state labs and offices and infrastructure, equipment. All of that is owned by the state of Georgia, even though the administrative part of the relationship is through the corporation. And I will say that there's a difference. Sometimes when we're negotiating with lawyers, and general counsel or outside counsel, it's a whole different thing, because when you have when you have a contracts person who doesn't have a legal background, and they're used to just processing purchase orders, or it's a lot of it's administrative and it's very rubber stamped. They rarely question things, but you start crossing out indemnification. You start saying, well, we won't accept liability, or we won't accept this, but we expect you to accept it. And then it gets to the IP, and all hell breaks loose, because you've got everybody sort of agreeing on things, and then it's like, wait a minute, how do you own this IP? You wouldn't be able to do this if it wasn't for us. We're giving you money. And our stance is, well, we're giving you our experts. We're giving you our resources. We're a nonprofit, so we're doing it at a very reduced rate. So our argument is, you wouldn't be able to do this without us. So that's where it sort of gets back and forth. And I haven't had those situations at Georgia State. I've only, what's that?
Just like the marriage, like you said.
Yeah, exactly. So I'm newly married, so it's still at the early stages. And I'm married to a lawyer, so that's like, oh shit. No, so I think that's literally the only. I think confidentiality is another one, and it's like we're not willing to fall on the sword, but when it comes to trade secrets and things like that. But that the IP is really where the bulk of the angst comes from, and we don't really explain it the way I just explained it. That's very candid, but we have people. Our general counsel oftentimes will explain that, or our tech transfer office will explain how it's a collaboration, and so that's really the biggest challenge is explaining who we are as a and just so you know, all Georgia all member institutions for the Georgia Board of Regents have research supporting organizations. So they may be called the foundation, the corporation. You can look them up. They're all not LLCs. They're all nonprofits within the Secretary of State, and some of them date back to the 80s. I think that's when a lot of them were established, and so it's helpful to know that because one of the benefits of having those is there are some things that we can accept as the corporation that the university can't accept as a state agency. There are a whole lot of contracting restrictions on state agencies, and that's why in order to remain competitive, Georgia has adopted this model of having the corporations supporting the sponsored efforts, and then many other states have adopted that. CU didn't. University of Colorado, their regents we were contracting on behalf of the state of Colorado, but I will say that they allowed for indemnification if you could justify it. And the way we got around it was there has to be a very exceptional circumstance. It goes through several levels of executive review. I need a written justification of why you require indemnification, and it could take two months, 3 months for that to get reviewed. It wouldn't, but that's what we would say. And it would say, okay, we'll just accept it because they just want to get done with the contract. But that's a little inside strategy. It doesn't really take that long, and if it's that important and there's that much money tied to it, they'll kind of push it through.
So, you mentioned IP ownership. We're certainly going to get to that. But before we do, Justin, we've heard a lot about like what's unique about having to negotiate with a university as opposed to another business. And, a lot of these, terms or provisions are going to be somewhat foreign to businesses. And do you have any tips for industry or corporations when working with universities to like not get too bogged down on that on the front end so that we can kind of keep the deal moving?
Yeah, it's a really good point, and I think the corporations need to understand that it doesn't work. You don't have employees the same way a corporation does. You don't have a set of employees that sign an employment agreement or a invention assignment agreement. When they walk through the door, you have faculty who are guided by their IP policy, or you have students who are not because they're not being paid. And so understanding that at the outset and sort of, again, aligning the scope of work, like, hey, I don't want any students working on this project because you don't own their IP. Fine, that's part of the discussion. And so the corporates, I think, in the world need to understand, that you might have people wandering through, you might have other things. And so it's not a good place for them to dump their trade secret. Like, even if they insist on it, oh, we're going to be telling you these things. The university is not really the best place for that, so maybe just keep it to yourself. And we can't, they get really hung up sometimes on the reps. It's like, what do you mean you can't rep? You own the IP. We might not, they might collaborate. They might go out to a conference and have a discussion, and there's joint inventorship, so those types of things come up all the time. The corporates, I think, just need to be flexible and sort of, yes, and it depends again on the size of the company. So if you have a big, multi-billion-dollar multinational pharma versus a small startup, they're going to understand things a little bit differently, and they're going to be either flexible or inflexible. So I think, again, aligning the interests, have that discussion up front, it'll really take you much further than sort of trying to come at it with, competing templates or documents, right out of the gate.
Yeah, no, I agree. It's all about having the conversations up front.
Yeah, and clarity over, that versus trying to be clever, right? Like if you can just align on clarity and say, hey, this is what we really want to do, here's the intent. And it doesn't often come from council. It comes from the scientists. It comes from company scientists and academic scientists. Like those people need to agree on what's happening. Then the challenge, of course, becomes translating what that work looks like to the legal process and making sure that the document you ultimately end up with reflects that and covers as many edge cases as you can, but you're never going to cover it all. I think most agreements, licenses especially, are often renegotiated, and I think the best ones typically are.
Yeah, you always want to have these ongoing partnerships, and we mentioned earlier, it's all about university wants to get the technology out, so they're in my experience, they're pretty open to renegotiating these terms as commercialization moves forward to ultimately achieve that same goal. It's not just about trying to generate royalty.
Yeah, and I think, if at the end of the day, you want to have somebody, you want the partner who can move it forward the quickest and, with, the most efficiency, right? Sometimes that's in industry. Sometimes that's at academia because we can do things cheaper. We have graduate students who can work long hours and you don't have to pay them $100,000, $200,000 a year like you would a technician in a pharma company. So, yeah, I think it's all coming down to conversation.
Yeah, and you raised a good point earlier about like students working on projects in regard to IP ownership, and I tell my clients regularly that that's something you're going to want to pay attention to. Every university is going to have a separate policy on how they treat ownership of IP created by students versus faculty, and then in what scenarios did they create that IP, and it's important to know that on the industry side, just to know what the university can actually agree to.
Yeah.
So getting on IP ownership, maybe Chase and Tim, you guys could speak to a little bit about how universities think about IP ownership when they're entering into these agreements and, maybe how they treat background IP versus foreground IP or joint IP, all of that.
Sure, yeah. And this is as probably every one of the topics we will cover this is something that warrants a discussion and alignment and some education between the parties from the start. Because if you just at the last minute come out and say, oh, by the way, we own all the IP, someone might be like, well, then what are we paying you for? And as we've mentioned, it is not that kind of arrangement. The university owns the IP. We can license it out, but we have pretty specific rules about what we can or can't give to third parties for free or a discount or less than a fair market value, a fair exchange back to the university and in turn to the state. We operate with state resources, and if we start giving those state resources to some unrelated third party, that's not really what these state resources are for. We can't just kind of co-opt them into working for Samsung. So we have very specific rules about if we're going to give you state resources, we need to be made whole for what we've given you, and it needs to, or we can benefit from it too, but then we start getting into, there are only certain ways we can benefit from it, but we can't just like rake in a big pile of cash because we are a nonprofit. We can't just start taking profit, but we could become rich with educational content. I guess this is all to say, the IP, we can't give it away. We can license it out, but giving more than that starts becoming more than incidental to the performance of the research. We're here to do research. If that develops IP, awesome. We want that IP to be put to use. But we're not particularly interested in any sponsor like becoming rich from it. We don't have a problem with that, but that's not our interest. And so if we start giving things away so that sponsors can become, enriched in some way, well, it calls into question, what are we doing here? Who are we serving? So that's kind of, there's a little bit of sticker shock sometimes of not being able to own the IP, but it's because we're kind of under some guidelines, from the IRS, from the state of Georgia, and in internal policy as well, about just what we can give to people. And specifics of background IP, foreground IP, all that stuff, I'll pass the ball.
Yeah, so it's interesting to hear these two, because it's all stuff that I've had specific scenarios where I've been in meetings with very high level leadership at the institution because certain things got to a level, and I am one of those people. I don't know why, but at every institution that I've been fortunate to work at, I have encountered, I can think of 5, but I know that there are way more than that, of situations that are anomalies, that are unprecedented, and I don't know how I get myself into these, how this happens, but at CU, we had 2 sponsors that didn't pay. Like, they just didn't pay. And one of them argued that, the deliverables weren't what they wanted, but yet they continued renewing the contract. I can't remember the name of the company. Well, I can, but I don't want to say. But it was a major corporation that did. I think they make light bulbs or something. I don't know. Whatever. But it was a pretty big company, and they had an entire team of attorneys on the other end with our executive vice president, our vice president for research, our director of contracts. This was at Georgia Tech, actually. And we were all sitting around, just like about to explode, because it's like, there is literally no IP that exists, none. We have no idea that there will be. This is an idea, and we're collaborating, and you're paying us a lot of money, and we get it, but there's no IP. So how would you, as Dustin was saying earlier, a lot of times they want to get it buttoned up in the beginning, and to just kind of avoid things down the road, but there's certain things you just can't anticipate. And there was no guarantee that any IP was going to result, and so there was no way to put value on it. And so it was very basic IP terms that just about everybody accepts, is that you own what you own, all the background, we own what we own. If we create it, we own it. If you create it, if solely create it, you own it. And then if there's joint IP, then we negotiate it at a later date. And that's usually pretty acceptable, because when you break it down like that, they're like, okay, that makes sense. But then for some reason, it's like there was just no winning. And so ultimately, our executive vice president, who has no background in IP, or he just does research, and he was recently appointed to executive leadership. He was, I think, a little bit out of his comfort zone, and he basically just agreed to accept things that we would never have accepted, just to get it to move forward and to shut it down. And I don't know if it was a strategy, if their strategy was to wear us down so that they could get what they wanted. It worked. I don't know what the result was, because I wasn't there to see how it could still be ongoing, the research. But I think the biggest thing is the unknowns, and having to sort of explain that right now nothing exists. So why are we getting to this point? Another big thing is the work product and the work for hire. Generally, universities don't do work for hire, and I know that there are statutes that require it to be explicit in the contract that this is a work for hire. I specifically take that out, and one of the things that I do, and I'm generally successful in it, is that I explain that we can't contractually agree to this, but if it ever comes up, which it's not going to, then we'll discuss it then. And a lot of times they're amenable to that because, we don't want to get hung up on, is this work for hire? Is it not work for hire? I mean, it looks like work for hire. And at the end of the day, it is work for hire, but we're not calling it that. And that way we own the work product. We're not employees. If we're independent contractors, which is what all of our contracts say, and then you say we're work for hire, well, those two conflict. And then you're saying that because we're work for hire, you own the work product. Well, you don't own the work product because we don't work for you. We work for Georgia State, Georgia Tech, or whoever. And so that's another big thing. And so I just basically, a lot of this stuff, I shut it down by just saying, we can't contractually agree to this, but we can certainly address it at a later date, and that moves it on.
I think one of the biggest things I see is that there's a confusion, especially on the industry side, of ownership means access. You don't have to own it. You can get the same provisions, like Chase said. You can license it. All of those things can be negotiated. And so if the company's really concerned about having access to whatever comes out, you can do that through options, through licenses. Give them some confidence that they're not going to lose access to the work that they're funding. And in some cases, you want to highlight, if you're on the university side, maybe, hey, company, you don't really want to own this. Maybe there's some NIH money in a center, and now you have NIH federal reporting requirements on those inventions. You don't want that, trust me, right? Let the university continue to handle that. Or, we can't guarantee that we're going to own it all because there's a student working, or, that kind of stuff. Again, align the scope of work and get past this sort of idea that you have to own it in order to control it. There's lots and lots of ways. You can do lots of things by contract, and university licensing, university-sponsored research all work together to sort of find that best outcome. With respect to background, foreground IP, I agree with your sentiment. Like, hey, if you come in owning it, you're not losing access to it. But at the same time, the university is going to want to have some confidence that they can continue to do research around some of these inventions, right? The professor really doesn't necessarily care about the commercial product. There are some who are more commercially minded, but at the end of the day, they don't want to develop something that then a company can say, you can't publish on that. Because it could be really cool. It could be something really valuable to their career. I mean, the Nobels are coming out this week. Like, think about some of the research that's happened there. If they weren't able to publish it, who should say what happens in their academic career? A lot of it too is, PIs don't understand sort of the access rules, explaining their science to a lawyer, trying to translate that into what happens on the commercial side. And so they may have trainees, or they may have other people that they're really worried about their careers, right? So if they work really hard on a project and now they're barred from publishing it or can't continue to work on it, that could really stifle a career of a budding scientist. And so they do care a lot about the upcoming scientists. So again, negotiating all those things is great, but I think you should really focus on, especially if you're on the corporate side, not forcing ownership. You're just not going to get it. The university has certain rights. They have, came out with the Bayh-Dole Act, started with federal funding. You're allowed to own the inventions that you generate. What you do with them after that, you have to just comply with, compulsory licenses for NIH reporting requirements and all the compliance associated with that. And then also, how do you monetize it, right? It's not to say you have to monetize it. You could give it away, but the university also can't license what it doesn't own. And until you create it, you don't own it, and you have to make those reps. And so the corporate should really think about that too, it's something to be negotiated at a later date. Works made for hire come down to software code, to all these types of things. If there's open source in it, you don't want to have that necessarily. So IP is a very broad term, so we think about it even as data sets. If you're generating a set of data that's very important to a company, maybe it's patient data. Like, the university or the academic medical center is not going to let you own the patient data. Absolutely not. So it's not worth fighting. It's, again, back to those third rails.
You make a great point that so many times, the industry, they get so caught up in having title to the patents, they want ownership. And, we learned this in law school. All these various forms of IP are just this bundle of rights. And you can have access and exclusionary rights as well. You don't have to have title. And I think it's important, particularly for the attorneys on the front end, to tell their clients and try to explain that. Yeah. That, hey, let's not get caught up and spend a month arguing back and forth over who's going to own what. Like, what matters is that can we get all of the rights to it? And in my experience, universities are very happy to exclusively license out the technology. Assuming you're going to have to commercialize it, they want to see it come to market. Yeah. But that's
and I think university tech transfer offices are not having their doors knocked down with licensees. And so again, having a built-in licensee, having a sponsor that's there, they have a vested interest in it. And so it's a great start to getting a commercial product, sort of moving along. Yeah, and getting even some access. So even if you get a non-exclusive license, to start, the university is going to have a really hard time licensing it elsewhere if they already have rights granted. So you're pretty much the guaranteed licensee. So I would not worry about it. Yeah, there's some risk, but the risk is greatly mitigated by just if the university gives up any small piece of rights, whether it's a field of use, a geography, or even just a non-exclusive, to practice or research, they're going to have to deal with that if they try to commercialize it exclusively later. So you've kind of got a leg up anyway.
So something else you touched on, and it's come up a couple of times, is publication. So if you're working with universities, all of these professors, they're in the business of publishing their inventions, right? They want not necessarily inventions, but they want to publish in manuscripts, various journals, present at conferences, et cetera. Where that can provide a hiccup sometimes, where you have industry that's like, they want everything staying as confidential, as they can, protecting it. Whether that's just because they don't ever want the information to get out there, or it's because they want to make sure they can adequately protect any inventions prior to publication. What tips do you see, whether it be like provisions for like workflow that go into agreements to kind of help, address both parties' concerns there? And then even if it's not like contractual, like just practice pointers that, both maybe it's particularly on the university side to talk to professors and give them guidance on, how to navigate these arrangements.
Yeah, maybe I'll start and then the university guys can chime in. I've lived that dream as well. Sort of the other thing corporate need to understand is that the universities are not resourced enough to go knock on the professor's door every couple of weeks and say, are you about to publish? Are you about to publish? And so timing becomes very important. The professors may have an opportunity to present at a conference. They may not know that for a couple of weeks ahead of time. They're also, with some exception, not the best at making invention disclosures or making disclosures to the tech transfer office, especially even around sponsored projects. And so there are some things that you should just be mindful of, I think, at the university, and the corporate should understand is that you're going to get a disclosure, you're going to get a publication, maybe not as far in advance as one would like, but you'll get it. And then so build some safety nets into those contracts, have a disclosure period and an opportunity for the company to request a delay of publication, not necessarily a bar to publication. That's one of those third rails. You're never going to get a university to agree a bar on publication. But you can delay it, to either file or have filed a patent application based on the content. Have an opportunity to review the manuscript, both for authorship and for potential inventions. So I think those things can really sort of go a long way and manage expectations, especially on the industry side as well.
Right, and also a publication review, we would be okay with that for screening for confidential information that we want to protect, but if giving the sponsor a chance to just make sure there's not any in there. Obviously publication is very important to the university. It's a big part of why the professors are doing this in the first place. So we have to not only be able to publish, but we have to be able to publish freely. So we can't agree to
editorial.
Taking directions about how to publish or what to publish. And additionally, we can't agree to too much of a delay when it comes to publication either. This especially comes into play with international contracts. But because it applies in international contracts, we do maintain some consistency with our domestic contracts as well, and we have a policy accordingly. But basically, export control laws have a safe harbor within them for fundamental research. And if you want to fall into that safe harbor, which we always do want to, then you can't have any unreasonable delay of publication. Because, the theory is then you have some foreign entity who is telling you what you can tell people the science said, right? So we're not allowed to agree to that. What specifically counts as an unreasonable delay is, not completely clearly defined, but Georgia Tech does have a position on it, which is, off the top of my head, it's like you can you have like a 60-day review period, and then if you find something, you can extend it another 60 days or something like that. But we have like a maximum, I think, of maybe 180 days. Don't quote me on that just off the top of my head, because we almost never have to push it that far. But you know, you get further than that, and you're delaying professors' careers. You're developing further development of this technology. You're letting any kind of you know, IP-related timelines tick away, and you're calling into question again the independence of the research that makes its way into the publication.
I think you can sequence this, right? So you can publish fast, you can patent first, it's all just sort of the plan, right? So have the plan built into the contract, have, you know, some reasonableness there, make sure the professor is aware. You know, you can, again, you're not gonna go out and police it and knock on their door every week saying, are you about to publish or you have an abstract? But encourage them to work with you and say, hey, this would be really good for us to send to the sponsor, you know. I found that if you dangle, you know, additional resources, hey, if they see this, they may be willing to extend your project or top you off on funding. You know, use some incentives like that to get the professors on your side. And conversely, you know, have the industry make sure that they're keeping up with the professor, right? They're the two collaborators. They're gonna be much more involved in the science project. And so there's a good opportunity there. And you can do your part to keep track, you know, whether you're counsel for a corporate or counsel for the university, you know, use the scientific context to keep the dialogue flowing.
Yeah, and I mean, don't ever, if you have any clients that are contracting with universities outside of Georgia, you know, and you just kind of want to understand some things before you go into any sort of negotiation, I would recommend reaching out to any of us for guidance, because, I mean, the more that you know going into, the I guarantee you the easier it will be. To kind of follow on to what both of them said about just the restrictions and the level of review and input that the company has on publication, there's also a student component, and there are students that participate in this research and they depend on the right to publish for their dissertation or for graduation requirements, and if they're not able to do that, and that's sprung on them, you know, at the last minute or at a time when it's just they don't have the time. There have been people, examples at Georgia Tech, where it has absolutely prevented, and I think it's ultimately ended in like loss and litigation. Not a lot, but I do recall a member of our export control team telling me about a situation where a student wasn't able to graduate. In fact, I think she was actually getting her master's, and her master's thesis, she wasn't able to, she had to pivot somehow and do something else, because there was and I think in this case it was the federal government that had put a restriction on disclosure of information. And I don't know how many of you are familiar with the federal acquisition regulations. They're just basically statutes that govern federal contracts. And just like with everything else, there's definitions. And the fundamental research, there's a definition for it. So you can't just call something fundamental research because you want it. It has to meet that definition. In some cases, you know, you may not be in the position to define that. And so there's a lot of little nuances that have to be taken into consideration. And so, you know, we always go into the mindset, I think everyone would agree, we always go into the mindset that there is a likelihood it will be published, because the dissemination of information is the fundamental purpose of every university, is that research university, is that we want to get it out. And so to even contemplate giving someone else the ability to approve it before it, you know, that's very subjective. And so rarely, if ever, do we allow approval, unless it's very specific on what they're approving for. If the approval is for confidentiality, you know, that's fine. We'll remove the confidentiality. If there's proprietary information, that's fine. We'll remove the proprietary information. But ultimately, we're not going to allow someone to dictate what we publish, because that's sort of why we exist as a university.
So kind of moving on to like the changes in the funding climate that we're kind of going through now, whether that's, suppressed budgets on the university side or less funding coming in from federal grants. Are you guys seeing any changes in how universities are approaching collaborations, like whether their willingness to enter into those or how they approach negotiating the agreements?
Probably.
I was going to say, I think especially professors are looking to other sources for funding. And so that could include philanthropy, it could include foundations, it includes industry sponsors. So no matter what the sponsor is, unless it's an unrestricted gift coming in, it's going to have some provisions around it. And so as the funding base widens, beyond federal dollars, I think universities are going to have, different things they'll have to understand. Foundations will want to understand what's going on, and there may be some specific rules about gifts coming from foundations and those types of things. So yeah, I do expect there will be some new things. Hopefully it's nothing too abrasive, for universities. I still think people want to get the work done. So yeah, I don't know. I haven't seen it just yet. The other thing I think that's important is that as most universities, and especially the public universities here in Georgia, offices like sponsored programs or tech transfer are funded on the indirect cost recovery. And so as those dollars sort of dwindle, they may not be resourced to have these long drawn out negotiations, or they may take a lot longer because you don't have enough staff or you don't have enough time to do that. And so I would say everybody just keep their cool, knowing that that's coming. But it still remains to be seen. I think it changes daily, sort of what's going to happen, at least with the federal dollars.
And we have started to see, so far, no kind of silver bullet, nothing super successful, but I think we have had a few sponsors start to think about, like, can I call this a gift? And the answer is largely no. Gifts are a particular thing that, as you mentioned, that they don't have conditions on them. You give money to the school and you say bye-bye to that money is the idea. Now, you might be giving it for a specific, you might be giving this money to a particular, like the School of Electrical Engineering or something, because you like electrical engineering as a company, but you're not going to get any deliverables out of this. You're not going to you're not going to be able to own anything that results from it. You're not going to be able to direct how it's used. So gifts are, I think, appealing to a lot of people as an avenue of, hey, can we creatively call this a gift? So far, I haven't really seen it work that well. But I do think people are searching for other avenues of getting things done.
Yeah, and I think with just about anything contract related, there's always a risk benefit analysis. And I think the lower the risk, the more inclined a university is to engage and to make exceptions and to sort of, they're inclined to be more flexible based on the risk. And that's ultimately what our role is to protect the university's interests as you are to your clients. But just like with anything else, if the risk is low, I think it makes a huge difference in the level of flexibility. And so if you're able to convey to the person that you're negotiating with, that the risk, a low risk, then it sort of softens the blow a little bit and may lead to a more congenial negotiation process.
Yeah, we've seen, I think, a little bit of an uptick at GRA here in Georgia, and fortunately, we don't fund basic research, so we always sort of say you have to be generating something, and that's usually IP. We want that tie back to the university. We want the universities here to gain some value from it. And so we turn down proposals that are coming in just looking for basic funding. We hopefully rely on the universities to filter some of those out first. That's why we may work primarily with the tech transfer offices, but I will say I do think with funding constraints and sponsors, especially the federal sponsors, not providing or grants getting held up for review, we do feel this. Fortunately, our budget has not been touched, but we're feeling the pain of our investigators of sort of the uncertainty and their trainees, sort of wondering how they're going to continue to fund, this sort of very meaningful work.
So another thing is, we entered into these agreements early on, and I've seen it go both ways. I've had clients from industry that start this out, it's a disaster. They're like, I could never do this again. I've had clients that start, like, they find one group that's doing, publishing in an area they're interested in a university. They start working, that expands to a different group, and you get in these long-lasting partnerships, which I think is always the goal. Do you guys have any tips on how industry and university can work together to kind of create these longer-lasting relationships that can, kind of continue to expand in the future?
I think a lot of that depends on progress, made by the scientists. The marriage has got to be right. If, the university scientist just doesn't work well with others or, those types of things, it's not going to happen. I think those things have to happen organically. It's one thing to sort of be interested in the science, but it's another to sort of continue to work, have that partnership. Success always breeds more confidence. And so I think if there's opportunities that, there's a success story, whether that's either publishing or something that's patented and a commercial relationship or transaction happens, I think that will continue to sort of say the industry will go back to the well, right? It's like, hey, why have we, sort of not continued to work here? Several professors at Georgia Tech are very entrepreneurial and continue to produce new companies all the time. Others not so much. And so I think, it's the innovation happens, and if an investor or a corporate is around the table, they'll see that and hopefully work that collaboration. I think the universities can do a great job of sort of enabling that, and corporate counsel, however big or small the company may be, can help sort of drive that too.
Yeah, I don't think that people in our position are that instrumental in those relationships. Almost always it's the research, it's the people on the front and doing the work, and the relationships that they have with their colleagues. But I will say that the ease with which we're able to facilitate that goes a long way. And if that relationship already exists between the faculty and the company PIs, and we just sort of add that extra layer of flexibility, I will not minimize that, because I've heard it directly from sponsors, and I've had conversations, and there are contacts that I have with corporations that I've worked with that I have had repeat interactions with. Some of them, it was crazy. When I first started at GSU, there was a guy that I worked with at CU. It was with some laboratory, and it was crazy because I got an email from him, and it was very it was eerie, because I'm like, oh, wait a minute, but it was, and I remembered him, he remembered me, and it was a great moment, because we knew that it would just be an easy process.
Well, thanks, guys. I think we're about out of time, but I certainly wanted to kind of open it up. I don't know if anyone has any questions for these guys. Maybe something we touched on but didn't get to elaborate on. So please feel free to ask. And otherwise, I'll just, if anybody wants to say anything.
I would just give an example. So here in Georgia, we had a company that GRA funded both at the grant side. It was a technology coming out of Georgia Tech, so well-known entrepreneurial professor. ultimately formed the company came back and raised money, and then put money back into Emory to actually run the clinical study. And I think all of that transpired because of clarity around sort of exactly what was going to happen. You know, we funded the company, or funded the technology. They were good about IP. They were disclosing. It formed a solid basis to form a company here in Georgia. After that, we funded them with some seed capital. They were able to go raise institutional capital because there was clarity around who owned the IP, what work was still being done at the university versus done inside the company. And then they were able to go and do a clinical trial. So this sort of gets to, hey, we had background IP that we already licensed. We had our own background IP inside the company. We put it into Emory to do the clinical study. Emory, you're going to own the outcomes of the study. You're going to own the patient data, but we want to have access to it to make sure that we can go to the FDA. That helps us raise more money. So this is a company called Micron Biomedical. It's out of Mark Prausence's lab. The study was done at Emory. It's a small vaccine microneedle patch. So all of that sort of had to gel and come together. And clarity on the contracting, whether it's the sponsored research side, whether it's the investors and doing diligence on it, sort of understanding that the IP is free and clear, and then the ability to go run a clinical trial and contract that, so industry-sponsored trial. The company was fortunate to raise money and put money in, and they didn't have to do that internally at Emory. So again, everything sort of aligned, and there's several case studies that come out like that, and so it's a great success story, and I think it does help that we had good minds around the table to do that contracting while it was still at the university. I don't think you can, again, sort of set them up for success, but you could certainly throw a whole bunch of potholes in the road, if you don't do the contracting and be mindful of that. So it does matter. We see it all the time, and so fortunately we haven't had to clean up too many, but we're trying to be mindful of that as we put money in early and as we put money in on the outside of the transaction as well.
Thank you for saying that we had good minds working on the contracting there, because I did work on that one.
Good.
I think one just last thing is I think the size and the level, the research level of the university, they have different R1s, R2, and depending on the nature of, I've had the benefit of working for Georgia Tech, which is, well, I mean, we're GSU is also an R1, but our level of our research portfolio is certainly not as sophisticated as Georgia Tech's and not as robust, but we're growing, and in a lot of cases, your experience will be different depending if you're contracting with UCLA or Harvard or Georgetown or Georgia Tech, MIT, and then you're negotiating something with GSU. The level of sophistication with the contracting, I mean, you're dealing with is the same, but the level of, again, flexibility, the experience will probably be a little bit different because Georgia Tech, they don't back down because they're Georgia Tech and they're very proud of what they do, which we are too. But we also, because we're growing, I've heard it said in our office. It's like, well, we can't afford to turn this down, so we have to make whatever exceptions we can. And if you find a university that's in that situation, you may have a better experience.
Well, I think Kenny's giving me the sign. I think our time is up. But guys, thanks so much for taking some time this morning to talk with us about this. It's very helpful. I hope everybody got some insights.
Great.
Thank you.
Thank you. Thanks. Start back in 10 minutes.
Thank you, gentlemen.
Thank you.
Thanks so much. Nice to meet you guys.
Yes.
Okay. There's another one coming out now.
Hey, what you doing? Nothing. What were you doing this morning? Tell Michelle she needs to come on over to College of Arts. Perfect. Thank you. What? What?
it's been a team effort between the three of us, so if you see him falling asleep, take him in another direction.
This is, I have the easiest job. Because she's so engaging and.
Well, you're very kind to say that. Thank you. I appreciate you saying that.
And I think people would be interested.
Do you? Oh, yeah, yeah, my mom drove me to school and back with a motorcycle. Kindergarten, yeah, and not like one day, that was means of transportation.
Okay. All right, so sit where
Ready for us to?
whichever seats you would like, yeah.
Okay, well, you pick your seat and you want me to.
Pretty cool.
Do you want just right here, you think's fine?
Yeah, this is fine, I think, you know.
Okay.
Maybe, I guess we could.
Today is cooler, but I don't know if it's because we have
I told them.
the temp, oh, okay. Well, thank you.
Okay, we'll go ahead and get started as people are getting corralled back into the room. So we'd like to have at least one session with a keynote famous person. And so that famous person is Jamie Renee. So congratulations. I don't know if you knew that.
I've
You
been
were
promoted to famous on
You're
the spot,
famous.
so I'll just
Well,
let you know that.
when you run a big national important organization like that, you know, you're famous. So. And Puya is a friend of mine who recently, over the last several months, has gotten very involved in the Georgia IP Alliance and joined the board. You did join the board, right?
Yes.
Yeah, okay. It's all, the last several weeks of meetings are blurring together for me.
And he recently made manager.
No.
Partner, even
Not
better.
managing partner, I'm speaking it into existence, I've been
Yeah,
corrected
so
several times.
congrats to Puya
Partner.
on his
Yeah,
partnership
yeah,
elevation.
Yeah,
Thank you so much.
you're welcome.
So Puya, thanks for all your help, and thanks to both of you for putting this together. We're really excited to have this this little chat, so I'll let you go ahead and get started.
Yeah, thank you so much. Really appreciate it. And thank you everybody for attending. I'm so excited about this panel. I had a few conversations with Jamie before this, and every time I was more fascinated than I was before. So I fully expect this to be not just one of the best panels in this conference, but in really any IP conference we've attended, but no pressure. It's she's just a lot of, she does what she does at the Academy. So let me go ahead and just get started. We're joined by Jamie Renee, who's the Executive Director of the National Academy of Inventors. She leads the only national organization dedicated to academic inventors, bringing together universities, industry, government, and communities to strengthen America's innovation ecosystem. So she's here with us to share how the Academy is mapping innovation at state and national levels, and why it matters for business, IP strategy, and the future of American competitiveness. So please join me in welcoming Jamie. Okay, well, thank you, Jamie, for joining. Can you start off by telling us more about the National Academy of Inventors, what it does, and what your role in that organization is?
Yeah, absolutely. So by a show of hands, outside, well, no, let's include the folks that know me personally, and there's a few of you. How many of you have heard of the National Academy of Inventors? A handful, yeah. Nikhil, you better raise your hand. We're friends. But so the National Academy of Inventors, for those of you that have not heard of us, maybe you've heard of the National Academies of Sciences, Engineering, and Medicine, and we are the fourth academy. So our academy is made up of those individuals that are a part based on their science, but they also have an added element. They have portfolios of IP, and they have translated that IP to generate economic lift. So we are the Academy of Science and Business, sort of poured into one. We have about 4,000 inventors, top inventors across the world. While we are heavily focused in efforts here within the United States, about 5% of our business efforts are global, and that is growing year over year. So we are a global organization that's primarily focused nationally at the present moment. But we've got, several thousand of the top inventors across all of the science fields who also have a foot in business. They've launched most of the technologies and life-saving devices, including COVID vaccine and every other thing that we depend on in society. And they also understand business and the responsibility for national security and economic lift. Aside of the individual inventors, we also have organizational membership. And so about 300 organizations across the nation, a handful globally as well, are members of the Academy. Those organizations are the R1s is how you would classify them. The AAUs, the R1s, the National Tech Labs, they're all members of ours as well. So any organization that does research, and the objective of that research is to get it out into society and to create jobs, et cetera, they probably are a member of the Academy as well. So for those of you that didn't know, now you know. Yes.
Got it. And can you tell us more about what you do at the Academy, how you ended up where you are at? What was your journey into it?
Well, that's a lot of questions rolled into one. Yeah, I'm happy to tell you. So I lead the Academy, but as you can imagine, I am always in a room full of people that are way smarter than me in almost every way imaginable. These are the top scientists across every discipline. And so I lead from behind. I know a lot of people use that expression, but that is a philosophy and a practice of mine. I do a lot of listening in my role. My primary objective, and if I sort of dovetail with what was discussed in the previous panel, is to get our inventors who are working with all of you and with industry as well, to be more cooperative and understanding of the conflicting interests so that we can speed up, accelerate the translation of science and inventions into the marketplace. So it's a lot of listening, collaborating, finding common ground, celebrating what it is that we want to see more of. So the success stories that we see that we would like others to emulate, we announce that to the world, that this is a benchmark, a best practice. It's a lot of sharing of best practices. It is a bit like coaching the Olympic team. When you're a coach of another team, you have 2, 3 based on salary cap star players. Well, we are the Olympic team where everyone is a star. And you coach that team a little bit different than you coach other teams. And so it's a fair amount of teaching individual performers who accelerate in their own areas how to collaborate in a team environment, which may not be the way that they've been successful throughout their career, but it is how we are going to accelerate economic lift and advance national security. And so it's a bit of coaching and leading from behind.
Yeah, no, that's fast. We actually had a conversation this morning, and I saw that in action. I was talking about some ideas, and Jamie mentioned it's good to have a collaborative environment, and I could definitely see. I guess, would you be able to? You mentioned talking about leading from behind. I'm interested if you could get more into what that entails. How much of it is deference to these individuals that you work with, as you mentioned, the brilliant minds you work with, and how much of it is do you have to set the agenda sometimes and take, I guess, more of a leadership from the front, I guess. How much of a mix of that exists?
Yeah, that's an interesting question. For those of you that know me or pick up on personality, deferring is not something that I naturally gravitate towards. If there's a better idea, I listen. If there's not, then we come up with it together, and that doesn't intimidate me. So the caliber of individuals, I'm almost numb to it at this point because they're all fantastic. So that doesn't bother me. But it's leadership and being on the team is very different. And I think that's what we were talking about that you are asking me to elaborate on. And I am not competing with the team. And that is the difference. And that is why I have the respect of these individuals and I have their trust and I get them to be able to collaborate with me because I made a decision through the guidance of my mentor at the time, that I no longer was the star performer. Being the star performer, individual performer, managing my areas of business and, meeting goals, accelerating goals, setting standards is what got me to the position of leadership. But to lead, I had to make a decision. Am I the leader, am I the coach, or am I the player? And many of you, we've talked about you now as partner and the responsibilities that shifts, the change of responsibility. Much of your time is in listening, understanding the talent of the people on the team, and then writing plays so that they can accomplish something together that they could never accomplish on their own. And you can't do that if you are competing with them. And so when I say I lead from behind, what I mean is they're out in front of me, so that I have a perspective not only on the ecosystem and the environment that we're in, but I'm also watching them navigate through it so that I can write plays. I know their names. In many cases, I've met their spouses. I know their children. I know their passions. I know their strengths. I also know areas that they want to grow in. I pay attention. I listen to them. And I can only do that if I am in the back watching them navigate the space, interact with each other, and then I can write plays where we can collaborate together and accomplish more as a team than any one of them would be able to accomplish on their own. And the reason I'm able to do this with folks that are rock stars again is because I admire them, I respect them, but that doesn't mean that I tell them yes when the answer should be no, and they respect that as well.
I see. Actually, you've alluded to it already, but I was wondering, in your own words, what do you see in this kind of a collaborative environment that you engage in? What do you see your role, and how do you see that what kind of a value add do you think you bring to these kinds of collaborative activities? Is it engaging people more with each other? Is it making sure they're focused on the particular task at hand? What kinds of intangibles and roles do you think you perform, and is kind of within your wheelhouse?
Well, it's funny that the majority of my analogies involve sports, and maybe that's because I come from a team of athletes on both sides, but I was the black sheep that did not play any sports and was studying in the stands and would, yay, had no idea what was going on, but everyone's cheering. But somehow, it's in my DNA, I guess. And it's so like any good coach. Can the team play without the coach? Of course they can, especially at this level in which I operate. But do they play better with the coach? They do. And the coach has a responsibility to not only understand the players, but to understand the ecosystem. I got to pay attention to the politics, the policies, the environments, the emerging technologies. It's my job to understand all of that and put them in the right position. They trust me to be good at what I do, and I trust them to be good at what they do. So right now, like this environment, many people are talking about obstacles. You're talking about the challenges with administration and policies and objectives, challenges to funding, what direction are we going in? I mean, the government, unless something happened, is still shut down. These are obstacles. Well, you play through the rain. So real leaders, real coaches understand that the move is not to stop the game. You get the people on the field and you tell them how to make adjustments based on the environment they're in. And so that's what I do. And the good news is, although I don't necessarily see myself as the coach with the clipboard and the belly sticking out over his, I'm going to make it gender specific, pants, I don't have to be the one to perform all of these amazing feats. I got to know, I have to at least be, if challenged, good enough to catch one of the balls, throw it a fair amount of distance, and I can, and that's why I'm here, but I don't have to have the resilience that they have. I've got to be really good at coaching them based on the opportunities, the environments, writing plays that help them play off the strength of the players that are on the field, and that is what I'm doing and what I enjoy.
Got it. Makes sense. I also wanted to touch upon sort of the innovation ecosystem and the space within which you operate. You've talked about how innovation that's as something that happens at the intersection of university, industry, government, and nonprofits. From your perspective and the academy's perspective, why do you think this intersection is important, and what are some intricacies associated with it?
Yeah, so I don't know, I'm going to back up a little bit and then I'll lean into that. Obviously, our country, next year we're celebrating the 250th birth of our nation. We are babies. We're babies. And, but we're having a birthday. And what distinguished us from other countries? Why people who had been doing this, society, much longer than us, why do they pay attention to us? In part, it's because of IP. In part, it's because in our Constitution, even before people had the right to be free, vote, make decisions, own a home, have a credit card, they had the right to IP in the fabric of who we are as a nation. So everything within our ecosystem is connected to IP. IP has forever been the example of the American dream. It is why I'm assuming the vast majority of you, with very few exceptions, at some point in your lineage, your ancestors decided that the American dream was worth coming over here, taking the risk, and coming over here for. For some of us, it's closer. It's in our immediate memory, but it's, for the most part, with few exceptions, it's a part of all of our journey. And what attracted us? That we could be something that we believed we could be outside of what we had always been. And that is in part because of IP. That's why our economy grew, that's why our population grew, that's why we got talent from every edge of the world to come over here and make the melting pot that is America. It is IP. I mean, if I was you guys, certainly we are, so you can follow suit with what we're saying. We are celebrating as the 250th birthday of our nation, the reason that we are so strong and the solution to make us strong again is very much rooted in IP. So not only is it the intersection, it's the foundation of who we are. Individual rights, saying my own thought can be protected and monetized. Literally, people had the right to that before they had their freedom or the right to vote. IP has always been the example. It is what drove our economy. It is what will save us in this situation, and we can't lose sight of that. America is a business. We were founded as a business. And so IP is at the center of that. That has forever been who we are. We lose sight of that and get in negotiations and contracts and think we're something else. But we are a business where people's original ideas and their own willpower and their own ability to move things forward is what makes us collectively stronger and will help us regain our position across the world. And anyways, it's an exciting opportunity. So yes, it is at the intersection, but is very much in the foundation and in the blood of all of us who are very fortunate to call this place home.
Well, I think most, if not everybody at this conference would agree how important IP is. So we appreciate those words. But I'm also interested in sort of your organization's role in bringing together these stakeholders. One of the impressions I got is that for this innovation ecosystem to happen, you need various actors to come together and cooperate. And it seems like that's a big part of the mission of your organization. So I was interested if you could get into why this collaboration is important between different actors like universities, government, private industry, and what role do you in your organization perform in making sure you foster this kind of collaboration?
Yeah, so, when you're collaborating individuals, but you're part of the same team, you have a shared goal, shared sort of vision. You're normally operating under one leader, and so there's some conflict, but not much. When you are multiple organizations, multiple sectors, multiple industries, and you're coming together as a team, you may not necessarily have the same goals. You could even have conflicting goals. You may not have the same language in which you describe what it is that you're setting out to do. There may not even be a unified vision of what it is that you're trying to accomplish. And that's really because people have not come together, sat down, and created that clarity. So part of what the Academy does, because we're working in those intersections, is we create a shared vision. Everyone is playing their own position, but we help them identify common goals. You know, policy, practice, contracts, yeah, this is obviously how we see work move, IP move, but it's people. And by human nature, people do what is measured, what is resourced, and what is celebrated. So we look at that. How are you measuring? How are you holding people accountable? Are there unified goals, metrics that you're tracking, lead lag indicators that you're tracking to ensure things are being accomplished? Where's the goalpost? Is there common ground there? Again, it's not refiguring things, it's creating common language. When you talk about resources, where's your budget going? How much staff are you dedicating to that? And then celebration. The earlier panel was talking about the conflictions in academia between publish and patent. And that's one of the issues that we raise. In promotion and tenure, this is how faculty and researchers get their position. They're very much looking, or, you know, in order to graduate or get a degree or to move up or get the accomplishment, the way they're celebrated is through publishing. We have put an effort, and it's in place in many universities, and it wasn't before we started that, where patents are seen equal to publishing. That is a way that we make the change. How are people being measured? How are they being resourced? How are they being celebrated? And if those people belong within the same team, or they belong to separate organizations or separate industries, the challenge of finding common vision, common resources, common celebration, common measurements is a little more complex, but it's not difficult. It just takes time. And so that's what we do, is we help bring people together, and things that historically were in place that really don't have a relevance, or they conflict with an overarching goal, we're able to address that. One of the ways that we're able to address that, though, is, again, our individual members that we didn't always leverage. 100 of our folks are sitting university presidents. 100% of our folks have solved some sort of societal issue, launched a company, have a large portfolio. They, from an economic standpoint, there's a handful of billionaires, vast majority are millionaires, and you know, these people's message carries weight. And so we have now started to put them in places where they're talking to their peers. They've got the evidence of success and what they have accomplished, the traditional measurements of success, and they are saying to other university presidents, other heads of research, tech transfer offices, attorneys, industry, they're saying to them, this is what was a barrier. Now I overcame it because I'm standing here and you know who I am. But if this wasn't in place, we could have got here a lot faster, we could have done a lot more. And so we're leveraging our members who, despite challenges, have found ways to be successful to now come back and create pathways that make it easier for others to move up without those barriers.
Got it. I was also interested if you could get into these different kinds of entities that your organization deals with. If you could tell us, to the extent you can, about the nature of your interactions with them, what kinds of, what the nature of your relationship is, what kind of activities do you try to collaborate with them or get them to focus on?
Yeah, I like working in a team in part because I don't want to do all the work. So the bigger the team, the lighter the load. It also makes it a little more fun. You know, I spend a fair amount of time working, and so I like to work with people that I enjoy. And so having a team around me to get things done is just a natural state. I naturally gravitate towards how can we collaborate, who can we bring, you know, in. I'm not worried about sharing the shine or the celebration or the success. It's funner when you're celebrating on the, the back end of an effort and there's more there for the party. So we collaborate in pretty much everything we do just because it makes the work easier, it makes it more impactful, and we have more fun. Something that recently happened was we have a federal funder, we'll just say that, who in this current environment is looking for solutions on how industry, government, academia, and nonprofit research are able to collaborate better together. So they were having conversations with us and saying, we need our individual states now to start to look at as if they are one nation, which is not something we've been asked to do. It's crazy, but again, we're 250 years old. We are babies, even though we think we're well established. But in our 250-year history, we've not really asked our individual states to operate as one nation. And now we are looking at the challenges that we're facing globally. We're looking at others that operate as one, and we are realizing that while we very much see the independence and uniqueness of every state, and then within that state, the cities, the regions, the industry, et cetera, if we truly are going to regain global positioning, national security, and we believe our philosophies are the philosophies that should be emulated, our states have to come together as one nation. So this is the conversation we're having. They're having with us. How do we do this? What are your thoughts? And so I simply asked, where are our asset maps on our states? Where are our state of innovation reports where we know what resources, we know the strengths, we know the gaps, how do we know what the workforce development, what are the philanthropic investments, what are manufacturing capabilities? What is the land usage? What are the tax codes? I mean, these are obvious questions. If we're truly, it's not like you have to be that smart to think of, these questions, but we started asking these questions, there is no answer. Again, I have to remind us, we're 250 years old. We don't have to have everything figured out. There's still opportunity for us to own. We didn't have to do it before. Now's the time's different, and now is the time to get it done. But we don't have individual state of innovation reports, and we don't have a national report. We operate independently, except we think that we are pulling from the strength of our entire nation. So we now will be doing the Academy will be leading an effort in collaboration with others to do state of innovation reports for every state and then give a national report so we can truly asset map where we are strong, where funding should go, what policies are working, what tax incentives and codes need to be established, need to be reinforced, stop competing with each other, which is going to piss a lot of people off who think they're good at everything, but they're not, and instead start directing our funding in the places where there's going to be the largest return on investment. We're going to be looking at workforce. We're going to be looking at K through 12. So how are we going to do it? Where's my Texas folks that are over there? I'm going to get with my people, and we're first starting Florida, Texas, and California for 1,000 reasons. It will first be those 3 states. 6 months later, we'll roll out with the next round of states, and then within the year, we'll be pulling it all together for the national report, and we'll go from there. But we're getting with EDCs and chambers and universities that have already produced reports. Now, what's the philosophy typically when you're a star performer and you don't collaborate? Give me, $10 million, I'll hire a research team, we'll create all new data points and put our report together. Right. If you're an individual performer, not me, you can call it lazy, I call it strategic. I said, let's pull together all of the reports that already exist from the perspectives that we already value with money that has already been spent. Let's read those reports. Let's see if let's spend our money in getting all of those reports from the EDCs, the universities, the data sources, et cetera. Read those, consolidate that information, and see if we can't come up with enough data points from the data collections that already exist to produce a comprehensive report. I suspect there will be gaps. I suspect there will be conflicting information, and we will spend our resources filling those gaps, addressing the conflicting viewpoints. We will produce asset maps, we call them state of innovation reports for every state, and then we will be able to have a national viewpoint, how we can make decisions from a White House administrative level, even a state level, and not have a comprehensive view of the assets within the state that we are advising. You wouldn't run your business that way, but we're running the nation that way. So we are addressing that, but we are doing it in collaboration with bright minds who produce reports that already are out there and create value, and we're finding common language, and then we'll go from there. But that's an approach that we take. We don't need to have all the answers. We pull people in who have answers to individual areas. We find where our blind spots are, and then we fill there versus replicating what's already been done.
Yeah, no, that's fascinating. And I think reflecting on that answer, just as you were talking, I could see where the faith in collaboration comes from, because a task so monumental as like a national comprehensive report on these issues probably cannot be done, at least not in a really resource efficient way, without collaborating with those who have already looked at pieces of that problem, right? So I could definitely see where that faith comes from. My next question actually would have been maybe better suited after that report was done, but I was wondering if you have any thoughts to share with us at this point about what do you think some of the biggest weaknesses in, I guess, U.S. Innovation ecosystem is. And I think you were alluding to some of it about regional focus and such, but I was interested in your thoughts about some of the shortcomings and some of the areas of improvement, in need of improvement, I guess.
So I mentioned that I normally lead from behind, and there's probably a very good reason why they keep me in the back of office with a small group of people, and they tend not to put me on the mic. And that is, I'm sitting up here struggling with if I give you the soundbite that can get quoted and published and credited back to me, or I give you the raw truth. I clearly am planning to go the raw truth route, but I am explaining to you that I understand this is not palatable for everyone. The biggest problem is ego. That is the biggest problem. Ego of states, egos of individuals, egos of companies. You know, everyone seems to think, and there are exceptions, maybe everyone in this room is the exception, and I hope that is the case, and that a fair amount of healthy ego is necessary. It's what gets you to take risks, chances, try something that's never been done before. But when you think you have all the answers, you are all the solutions, you are the satisfaction to meet every single possible need that is out there, it prevents you from seeing anyone else. And that is what I think is the biggest challenge that we have right now. Now, oh, the screen's changing in front of me, and I thought it was doing it behind me. But no, data is running through this screen up here. But I think that's the biggest challenge, is we put our egos in check. If we put our egos in check, we're going to be able to do so much more. And here's the thing. There is room for all of us to shine brightly. There is room for all of us to be rock stars. There is room for all of us to be brilliant and to be contributors. We do not have to have all the answers. We only need to have the answers for the piece that we have been called to do, for what it is that we have decided is our contribution to society, whatever is our passion, whatever is our gift that we have leaned in to. And if you're not in your area of passion and gift, that's a different conversation, not for now, but happy to have it. But that if you're in your area of calling, that's all you have to know. But that is not the complete picture. And when we walk around and we act as if our university, our organization, our role within our respective companies, even our state, is the solution to everything. I mean, who wants to eat a meal where there's only one spice? It's the combination of the spices that make it fantastic. It's the combination of the ingredients. Who wants to watch a game where it's just a quarterback? Who catches the ball? If it's just the quarterback on the field, it's every single position that makes it interesting. Wants to listen to music with one instrument. Some of it is good, but the variety also creates flavor and interest. And so I think once we stop competing with each other, once we get our egos in check, realize you can be fantastic, but so can your neighbor, then we'll start to see solutions because people will understand it's a team effort, and that's how the game gets won.
I see. I was also interested in, I think, something that the previous panel also touched upon, the issue of fostering innovation in scale. How do you create, as an institution, a culture of innovation? Since you've had a lot of exposure and experience with these types of institutions, I was wondering, but the lessons you've drawn from successful practices at these different kinds of institutions.
You know, whether it's innovation or it's anything, if you are, you know, running a line of business or you here are running your company, I'm not going to say anything that's unique to you. Again, it's human nature. What are people motivated to do? And they are motivated to do what is measured, what I'm going to be held accountable for. Someone checking in on me. Is someone asking me to provide proof that I have accomplished that? So what is measured gets done. What is resourced gets done. Whether it is people, it is technology, it is budget, it is funding, that is what gets done. What is celebrated gets emulated. That is what gets done. So if you want a culture of innovation or you want to see fill in the blank, X, Y, Z, you have to look at the way that you are structuring your budget, your goals, your plans, how you're recognizing your people, what do your meetings look like, what are you saying externally and internally. You have to measure how you are organizing the entire organization and the population of the people in which you manage in a way that it is very obvious that that is your objective. So if your objective is to drive innovation, how much of your budget is focused on that? How are you measuring that? How are you celebrating that? Rinse and repeat. And the people will do it because that's how it gets done. It's definitely, too often we think, all right, I'm going to throw these goals up there. And then we put our people in positions where they don't have the resource, it's not being measured, so they think it's not important, and it's not being celebrated, so there's no personal reward for them. There's nothing for people to emulate. And so we wonder why they're not accomplishing the goals, because people are forgetting to look at those very simple 3 fundamental things that motivate human behavior. How are you motivating the behavior? So in this case, we're talking about innovation. We can plug anything into that dynamic. It's the same combination or recipe for success.
Yeah, that's interesting. And I guess what about IP attorneys? I'm curious, since we're talking about IP attorneys in these types of institutions. What role can they perform? How can they, be part of a broader innovation fostering infrastructure, I guess, for those types of institutions?
All right, so I'm speaking directly to you about you. And so, sometimes they think that you guys are the savior and you have all the answers and they look for you to fix everything, guide everything, instruct everything. Sometimes they think you're a pain in the ass and you're complicating everything and you're dragging it out and you're creating problems where they don't, need to be. And you're probably a combination of exactly what you need to be in the moment. But I think the key there is you're in the moment. You're in every single moment where ink hits paper and deals are struck. You're so instrumental. And yes, you are dealing with the leadership and the personalities from both sides. But I heard wonderful things said in the panel before us, where they were talking about just the spirit in which you approach the deal. The understanding the common hiccups that you could experience and getting ahead of it, to creating solutions instead of a stalemate. So it's just you doing your job really, really well, wanting to close the deal, knowing that it's a give and take, taking the experience that you have, creating clarity and comfort for some of these very nervous people who are going into partnership. They're trusting you to make them feel comfortable and to do something that may be slightly uncomfortable for them because you have their best interest, the company's best interest, the IP's best interest in mind. And so just doing your job, very well and creating a place where people trust, feel comfortable being vulnerable. I mean, keep doing exactly what you're doing. So I have no words of wisdom for you, but it's not the place for you to, similar to what I'm saying, throw tomatoes at me or immediately stop listening. But it's not the place for you to show up with your ego. We already know you're fantastic. Your attorneys, your IP. We know you're brilliant. We know you've earned the right to be here. It's not the place to flex. It's the place to ensure collaboration. They are counting on you. You are the safety net. They are counting on you to create an environment of trust in a contract. And you do that through conversation, you do that in writing, and if you have any other agenda, then you're creating a problem that is unnecessary. No tomatoes? Yeah.
Yeah. Well, yes, absolutely. So everybody needs to have their ego checked. So, but I was actually going back to the whole innovation space. I kind of digressed with that IP question, but I wanted to get your opinion about some underexplored opportunities for collaboration in this innovation space. I guess if you had all the time in the world and all the resources in the world, what would be some of the areas that you would pay attention to that maybe are being underexplored right now?
I mean, that is a layered question, and depending on what angle we wanted to go, my answer would be different. My answer really is a lot of questions, is how I would handle that. I mean, I think I'd ask people in, the different sectors without limitations, what could you accomplish? With resources, what could you do? I think there's some very obvious structured things when we look at the technologies, if for no other reason, funding will follow, that the administration is saying are the 5 areas in which we, should invest. I think I'd back up and say, okay, how is our K through 12 system preparing for the future workforce? Because when those industries come out, do we have the manufacturing capabilities and the talents to bring them to market? If not, we are going to take our IP and ship it somewhere else in order for it to be manufactured, ship it back. Now let's start talking tariffs. I think I'd walk those things out. Let's connect. If this is a multi-year investment, this isn't a term investment, this is a strategy for the next decade or beyond, well, then you have to be looking at how you're preparing the workforce. Obviously, in our very short history, when manufacturing was the way in which we were an industrial age, where manufacturing was the way in which we got things done, that was our strength. We trained our students, our workforce, whether it was through the public education, it was through trade schools, it was in the university sector. We trained them to be able to do those jobs. Somehow, now we are talking about going into another sector, 5 sectors to be specific, and we're not having conversations about the workforce. So we want, companies to build manufacturing capabilities when our direction could change based on the term of the presidency, the whim, of the leadership. And so we're going to make, decades investments when there's no workforce that's going to be able to come into those manufacturing capabilities. It doesn't make sense. It's so that's what I would say is I'd ask questions. That is the missed opportunity. People are doing sound bites right now about, falling in line and seeing opportunity, but we have not walked out the trajectory of all that is necessary to bring those products to market, support those products, and a lot of it has to do with workforce, talent. We have technology that's sitting on the shelf, not because there isn't funding or a market to buy it. We don't have manufacturing capabilities to bring it to market. Shame on us. So we should have that same sort of philosophy right now as we drive in a new direction. What is it that we need? And that is in part why I think the asset mapping, state of innovation reports will give us a better lens of where do we have capabilities and where can we quickly accelerate progress to get up to speed with the smallest investment. Where are we ripe to grow?
Just out of curiosity, do you have like an estimate of when you think that report would be ready, or is there a target date for when it's supposed to come out?
Yeah, I mean, we'll hit our goals because I'm competitive. So it'll be out, within 6 months. But I have given for the 3 states that I'm saying, we will have Florida done, and then we will roll out from there. When the funder came to us, I will walk away from money before I will compromise my values. And I'm very fortunate that my board is in support of that. And so when the funder came and they had their terms of, we want you to kind of create the information, we want you to get out there, take the leadership. And I said, how dare us not listen to who is out there? I will not compromise who I am and go into the space because you want to give us funding to do this. I'll lose credibility, and I have an obligation, if to no one else, my mother and my father, and my grandfather and my children, to not approach work that way. So I'm saying, I'm saying in a fundamental way that we will listen before we act, because that is the respectful and right thing to do. So will the initial uptick be a little bit slower? It will. Will the end product speed up and be delivered faster and be more comprehensive? It will, but we'll see traction within 6 months and a delivery within 12.
So I think your point, if I understood it correctly, is that there's an initial sort of collaborative infrastructure that needs to be laid down.
It's getting the right people on the field.
Right.
I've got to assess their current talents. So, and I'm going to put it in different terms, not in sports terms. So first, you got to recruit your team. We're finding all the key players across each of those states, California, Florida, and Texas. So we're recruiting the people that we are going to have on the team, the stars. Then we got to assess the talent. And this set is it's data, what reports already exist. Then we got to combine that to write a new play, which is State Innovation Report for the state, that is a combination of all those perspectives and data points. So it's very simple. It's not, most coaches think very simply. You know, it's pull the team together, assess the skill set, then produce the plays. And that is the approach we're taking.
I see, and I'm so looking forward to seeing this report. It seems like truly a monumental task, and I guess that's sort of relates to my next question, because one thing I find sort of interesting and striking about your job is how complex and multifaceted it is, and how much it requires relationship management with different types of actors and different types of institutions. So, and I know previously when we talked, you shared with me some of the lessons you've learned about this relationship management. I was wondering if you could talk about that for the conference, about how you go about managing these relationships and forming them and preserving them over time and work through them.
I value people, and I think people know that. I don't pretend to be perfect. I also don't pretend to be good at things that I'm not, but I surround myself with people that are really good at that. When opportunities come to me, I immediately think of the skill set of collaborative partners and how I can pull them in. I'm not afraid and actually enjoy the competition within a team as much as, within the sector. We have a lot of fun. I don't know that it's always appreciated, but, we talk a little trash with each other, so people want to show up and collaborate. And the reason that we can talk it is because we know there's mutual respect. The reason that we can talk it is because I know enough about you and you personally and professionally, and you about me, that it's not a superficial, egotistical joke. It's fun, and you know it. So a relationship is, I know myself, and I know my limitations, but I also know my strengths. And I respect other people, and I allow room to be wrong, to be different, to apologize, to change my opinion. I think if you're fun to hang out with, people want to hang out with you. And so it's really that simple. And when you're operating at this space, those people bring big ideas, big capabilities, big industry, but it's no different. Think of who you hang out with. You hang out with them because you enjoy them, I would assume. Maybe there's some other strategy at play, but again, different conversation, different day. But you hang out with who you enjoy, and you have conversations with them about the things that you're passionate about. And so it's natural and it's real. And I'll say the other thing, I am way too busy and way too simple to speak out of both sides of my mouth. What I say, and I think people respect that. Is I don't talk about doing what it is that you're good at. I don't take credit for what it is that you have done. And so even if I'm in a room that you would never hear what is said, and you would maybe not be in the room, if I'm in the room, you're in the room, because everywhere I go, I take you with me. And I have built great, loyal partnerships with people because they understand when I'm in the room, If I consider you a friend, if I consider you a partner, you don't have to be in the room physically. You are in the room because I am in the room and you are a part of me. And that shows up in the way I strike deals. It shows up in the way I present solutions. So it's just about being a good person. And it's not overcomplicated. You know, it really isn't. Someone has a good experience with you, and then they refer you to someone else, and then they have a good experience with you. And not a perfect situation. There's a fair amount of times, I mean, I was raised predominantly by military men, and cussing is how we show love. And so there's been a fair amount of times I've had to apologize for what I would have thought was completely appropriate, passionate exchange of words, but in the mixed company, they're like, we don't talk that way. I'm like, that's the only way we talk. But, you know, and so I've had to apologize, you know, sometimes for directness or approach, but it is received because it is given. You know, I accept apologies and grace. I mean, I feel sort of ridiculous saying this, but I think we sometimes forget when we're in business that we're in business with people. That's it. It's people who want to be seen, want to know that they're valued, want to know that they can trust you, want to know that if there is some insight and some gift that they have and they are entrusting you with it, that you don't get into a situation and cut them out, that you bring them with you. Even though now I know how to make, you know, I'll give it to you different, even though now I know how to make your recipe, I don't make it, that's your recipe. You bring that to the table. That's the value you bring. And I think too many times we get into business and we lose the fundamentals of loyalty, and that is why people don't want to collaborate. So it's just being kind, being real, expecting that you're flawed and everyone you're working with is flawed. Say you're sorry, hold yourself accountable, and move on. It's not complicated.
Yeah. Yeah, no, that's very well said. And I gotta say, one thing that you mentioned when we spoke earlier and stayed with me is the point you made about how the same leadership qualities that work within an organization internally work with other kinds of stakeholders externally. And really, they're all about respecting people and getting them to feel involved in the process, right? So that really resonated with me. So turning back to the issue of IP to keep things exciting, I was wondering in your observations and the work you've done with these various institutions, and I'm sure you've seen a lot of different strategies about IP and issues of tech transfer and licensing. What are some approaches that, in your opinion, have worked better? What are some that haven't worked as well? Just your observations about these issues.
Yeah, I think it's, you know, we're collecting new best practices all the time. And the environment it's a living environment, so it's changing. So what's great today is not necessarily great or best tomorrow. And that's kind of the fun of it. You know, we're evolving individually, but the space we're in is evolving as well. We've actually, from a separate charge, been directed to create workshops for C-suite executives across industry and presidents, VPRs in academia, along with leadership decision budget controllers in federal entities to come together behind closed doors to have candid discussion, but workshops around how do they collaborate better in the present day environment with the present day objectives, resources, and challenges. And so we're in the process of doing that. And when they asked us, you know, would you facilitate these conversations, I immediately started making phone calls to some people, you know, that are in this room, some people that were in the conference yesterday, and others. I immediately, as soon as the opportunity came, started saying, hey, what's working? What do you see? Do you want to get, you know, pulled in on this? This is what's happening. I think you should be an instructor. You know, we're, in my language, all right, I'm pulling together a team. Who's our top talent out there in this space? And they're like, all right, on it. And they start recruiting folks for us. So, you know, some of what I'm seeing as the best practices right now, which I want to be clear, will not be the best practices always. You know, the right thing at the wrong time is wrong. And that is a simple expression that is just true. Just because it's the right thing doesn't mean it's the right time, and so therefore it is wrong. What is right now, we are in a different situation than we have ever been in before, in so many ways. And because of the way that this administration is moving, operating, doesn't matter what side. If you're indifferent, you're pro or you're adamantly against it. It has created an opportunity. Status quo has been shooken up. And because of that, everything that we have always done, we're not limited by it anymore. We're not restricted by it anymore. Opportunities to consider doing things different are a necessity now. So for people who, need everything to be predictable, they're very uncomfortable. But most of the time when people are uncomfortable, they stand still. So they're not in the way. They're standing still, and we are moving. So there is opportunity to do things new and different right now. If you would have asked me this a year ago, I would have told you what was in the playbook for best practices, because we had that, and it wasn't one size fits all. That is not the world we are in today. And if we pretend to think that today is the same as it was 12 months ago, we are delusional. It is not. This is a different time, and it has tremendous opportunity for people who are not paralyzed by needing direction, paralyzed by what is comfortable, paralyzed by what they have always done, paralyzed by approval, but truly are willing to see a path forward and lead. This is an incredible time for those individuals. And best practices are being written right now for this time.
Yeah, that's fascinating. And actually, I'm very curious. Would you get into that more about sort of the exigencies of this time or the time we live in? What are some examples of areas where you think new practices are emerging or the old way of doing things are no longer?
All right, so I'm registered as an independent, just in case anyone's sitting there wondering right now what side of the fence. And frankly, because I think both sides are pretty ridiculous when all they do is lobby for their individual side. But not that you asked, but for anyone that was wondering, not making a political position, frankly, I think there's a fair amount of people in leadership roles within politics that are not leaders and have no business being there. And I'm pretty critical of people who call themselves leaders. It is an awesome responsibility, and if you don't want it, you want all the glory but none of the responsibility, then you need to get out of the way, because you are doing a disservice. I think there's a fair amount of people in politics that have no business being leaders, so that we're clear on that. That being said, some of the, I think it's funding. You need resources. You need resources to get things done. And I know I'm repeating myself, but it's not overly complicated in seeing where we're at right now. Funding is being cut. And since funding is being cut, or it's being directed in a different way, since I did in the private sector before I moved into this role, acquisitions and mergers, and I was pretty good at it. I actually enjoyed it, and not because I was coming in slicing and cutting, but because I was coming in evaluating what was strong, where there was opportunity for collaboration with the client list, where it was all the analytics of it that was exhilarating for me. I think this approach reminds me of some of those practices during acquisition and merger. They're coming in and it's just deep cuts, which are not strategic, not the smartest way to do things. You cut off things that are living when you go too deep. But you're seeing cuts in the way in which government operates. So that means there's an opportunity for technology. Staffing budgets are going to be cut. I'm getting the sign that there's 1 minute. At any rate, it was at him. Well, it was directed at us. We are a team, and as much as I appreciate you singling us out, we're together up here. So we have a minute.
Yes.
But so it's everywhere. When the budget's being cut, the staffing is being cut, there's opportunity to rethink the way you do things. You're going to need to get them done more efficiently. So that allows for, how are we leveraging AI? How are we leveraging, what are our operating systems? What's the technology that we can use? How can we approach workflow? Are there checks and balances that need to be removed because they create no value and they're historic and inherited in nature? It's everywhere, which is scary as hell and also incredibly exciting. And here we go next year into our 250th birth of a nation. And every single one of us is here at a time where we get to influence what our country looks like, what our nation looks like for the next 250 years. That is an incredible opportunity that excites me. So everything's up for grabs. And the good news is most people are scared shitless and they're standing still, and it's real easy to move around someone that's standing still.
All right, well, that's fascinating. I had a list of questions that I almost halfway through and had so many other questions based on what you said, but really appreciate you taking the time to speak to us. I was really inspired, and I think you put our jobs in a much bigger context than we usually put it, in the broader context of what IP means for innovation and what innovation means for the country and the world. So that was truly inspiring. I appreciate you taking the time and for everything that you do at the Academy.
Thank you.
Thank you.
All right, so we're going to move on to lunch, which is served next door in the salons. And we will have a lunch panel, but the panel will not start until noon. So you have time to just chill and relax and, talk to me and stuff.
No, I mean,
No.
Thank you,
I need
guys.
pictures. I was here.
Very impressive.
Yeah, thank you so much for all the hard work. I keep saying that. Do you? Yes, ma'am, absolutely.
Researcher, dynamic. Search? Like, yeah, it means both. Dynamic, I think, is the technically it means somebody who searches for something. In recent times, it's used. What do you mean? Like, it's a different. That's what I'm saying. Like,
All right, I'm heading out, gentlemen. Again, great. My hands are freezing. I don't know why. I'm not super cold, but all right. So India from I definitely want to pick up on that. National and states, I think are state is moving. National, we need clarity. We need clarity on, and then I want proposal. Yeah. Yeah. State, I think I have good traction in states. It is all figured out, but I have enough that I can from up. And where I need support is I want to. I have a plan for the nationals that I would like to asset map. I would like to asset map all of the national organizations. Get clarity and identify the thing that we can do together. India, I have no idea, and I need a lot of support, but I've got a lot of really good people that I'll bring to the conversation. Yeah.
Are you familiar with the reporter and their
Competition, Carolyn Ward.
that show where patterns are being developed?
Oh, yeah, the map. Yeah. Yeah, that's not what I'm talking about. From a national, I'm saying the individuals who are on the national committee, I would like to know what is the mission, the goal of their respective organizations, and how do they measure success first. Then I want to know what resources they have within their organizations, and if we can find common ground on their resources to do what we are already wanting to do individually, collectively, better than we could have done alone. That is what I need. Yeah, that is what I want to do. Yeah, okay. All right. But that I need help with, so I either need permission to come in and just do it.
Yeah, you just.
But I mean, you have to just, you have to tell them, you know, that I'm taking from you. And then India, be at the table, let's listen together. All right, I'm heading out. All right, have a good rest of the day.
Yeah.
So are you based and I guess, were you initially based out of Atlanta and then?
No, I was based out of Chicago and I moved to
I see. I think I now remember, I think I saw you on that city event with the person
Oh,
from
yeah.
HPE. Were you there?
I could be.
The one at the Trotman area.
Yeah. April, yeah. I was.
Yeah. So, good to see you.
Yeah, good to see you.
Yeah, I'm very curious about the kind, I guess what work, is what US IPA does more national?
Yeah,
Because it
national. USIP is national. I mean, the kind of stuff that you're talking about. Connecting with different organizations, trying to bring everybody under one umbrella. Going on a joint mission and drive things. Otherwise, we're doing separate things in our own side.
do you guys do policy work?
We don't do lobbying, but we don't mind talking about policy and fixing the effect. But that should have both sides of the story, not just like one side.
So I guess it's not like, what is it? AI, what is it, AIPA?
AIPLA. Yeah, AIPLA is a.
That's more like they have a point of view.
Yeah,
and
they have a
stuff.
point.
But
Because
yours
they're
is
law,
kind
like
of.
there's lawyers. We have inventors, we have academics. All right. Yeah, so you should be involved. I'm glad you are.
Yeah, I am, I'm trying to
Did you
get.
sign up to the USIPA on the website?
No, I
With the
didn't.
newsletter?
Yeah, I'd love to get federally involved. The only reason I'm involved with GIPA is because that's the one I
That's the one you know.
wanting to first.
Yeah,
But
slowly
I'd
we'll
love
get
to-
you involved. Are you connected with Iran anymore?
With, well, not in Iran, but with Iranian American, like we have a bar association and all that stuff.
But are you not connected with anything happening in Iran?
No.
Because that would be helpful because we're below the GLIPA. We are trying to reach closer.
I see.
Yeah.
Well, I do, know of people who are more connected. So if you're interested, I can definitely put you in touch. I follow this page on Instagram that's like some Iranian nonprofit focused on patent and IP. So, and I do know of folks who are IP attorneys who are more connected than I am. So if that's ever an issue,
Yeah.
it's very much, as you can imagine, less developed than
Yeah.
not just US, but
Yeah.
probably much of. I don't even think they have an examination system. I think it's more of for patents. Like it's just record the patent. You don't get like a presumption of validity. You just record it, and then during litigation, they figure out if it was new or. It's like different. I guess.
Fascinating.
Yeah.
That's fascinating.
Yeah.
Yeah, it's not easy
To
setting
each
up a
their own.
patent office. Yeah, but it's not easy setting up a patent office. I mean,
Right,
you just
right,
gotta-
no,
once
absolutely.
things happen, it's not easy.
Tell me about it. I have to deal with them every day.
Yeah.
There's a lot more interaction.
Yeah, yeah, we're good now.
Y la semana antepasada me la pasé entre visita, Nashville. O sea, no me acuerdo la última vez que no tuve nada que hacer. Sí, chévere. ¿Y tú estás acá? Ah, porque tú te lo llevas. Bueno, claro. Qué puntería para enfermarse. No queda de otra. Sí, te voy a introducir con Natalia y luego me salgo. Natalia, bueno, ¿cómo te? Mariana, Natalia, Mariana es nuestra aliada aquí en los Estados Unidos y con ella trabajamos y tenemos todos nuestros clientes que comercializan productos que tienen interés de vender por Amazon, por Walmart, por todos los canales e-commerce, ¿verdad? Y ella se encarga literalmente de absolutamente todo de la A a la Z. Entonces, bueno, toda nuestra confianza con ella y por eso, pues, te la referí para que les ayude. Y Mariana te presento a Natalia, que es parte del equipo de JC Simón, que, bueno, ella te irá contando mucho más de todas las cosas que tienen, pero el señor Juan Carlos Simón es una persona súper renombrada en nuestra República Dominicana en el ámbito de cuidado personal, el cuidado físico, los ejercicios, la comida sana y saludable. Entonces, tiene unas líneas de productos, de suplementos alimenticios y bueno, ya los están vendiendo, los habían estado vendiendo por Amazon, pero están teniendo un inconveniente y ahí es que entonces es donde entras tú. No, yo desconozco absolutamente de por qué, cuál es el problema, etc. Pero bueno, esos son. Y ya verás conociendo lo magnífico que es trabajar con la familia Simón. Y ahora me salgo. Las dejo en buenas manos mutuas. Chao, besitos.
They called me. It was like as soon as I turned 18. They called me for jury duty.
Are you serious?
Yeah, but it was like a month, like the same month, or the month after. And they called me. I had just moved to my new, like where we live now in Brookhaven. So that's the cat. And they called me for folding. So that's how I got out.
Oh.
Yeah. Damn. Oh. That's how I got out of it though. Attention to detail. Now they have cold water.
Exactly.
Attention to detail.
All catering it.
That's what sets Georgia State apart from others. Can get re-refrigerated. That's it, right?
And then I need to put a few down there on that little ledge. Anytime you're setting the beverages, you always want to have the thing forward facing. Another thing is we put it to the right over here so that it's not in the way. Make sense? Is that my friend from yesterday? You were here yesterday, right?
Yeah.
How are you?
Good, good.
Did you eat the grilled portobello? How was it?
Thank you. It was very nice. Thank you.
My pleasure. So right here, on the right
You
side.
said the right side, right?
Yeah, so look,
That's the left side.
right. Boom, right.
So
person.
this is for this person?
This is,
Okay.
this is for this person, this is for this person, this is for that.
Okay, okay, okay. I was thinking the other way. Opposite day.
Everything else should be fixed already. There you go.
It sounds like some culture. They just not see it there. Let's do this. Put two more up here. Why not?
We have to do this every hour.
Every hour?
That's what we've been doing all day.
Every hour? You come in here and place the lock.
Let me show you.
emceeing this.
All right, we've got 2 bottles of water up here each. So that should be good, and they're chilled, they just brought. Panel leaders have 4 waters. Who's gonna grab it? In there, you going back in?
Yeah, I'll go back.
Oh,
Yeah, I'll go back.
all right, okay.
One or two people. Hey, you having issues with the Wi-Fi or have you been? No. You're good?
You're good?
Okay. On the GSU guest? The GSU guest network? Okay.
It's very strange.
So, I mean, yeah, it can be finicky, I guess. I'll ask around and
No, it could be
see
my,
if they can do anything.
just me.
Please make sure I weigh this one heavier, make it clear font, very small. It's crazy. Because my kids are 14. My 14. Oh, yeah, no, 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 it's not. No, 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 it's yeah. So I'm not that I'm not paying attention to you, but I don't know what I would do right now. I don't know, like, just right now.
It's hard. I don't know how you do this. Like, I've got, just flying at home. Not at home, but at work. I'm working on one right now. I think I told you the financial model for our Gen IDF. I really want to hand it off, but I want to make sure that this goes well too.
I'd like to call this meeting of the Jedi Council to begin. Disturbance in the force that we need to discuss.
I was just, touching bases. I did change out the water, but I just want to make sure it was cold enough for you.
Thank you so
My
much.
pleasure.
Hello.
Hey, how are you?
Good. Do we have assigned seats here?
No.
I'm Jason Chang. I think we.
Yeah, we just met.
All right. Sure, Jeff will probably sit here as my guess.
Yeah. Hopefully get started soon. We're already running late, I guess.
Yeah, we are. We're running late. All right. Spread out.
You have slides you're gonna go through?
No,
No, me neither.
no, I have the slides that Jeff,
Yeah.
and you remember when he told us to say something a little bit more about our companies?
Yes.
That's kind of why I wanted to remind myself of some things I wanted to cover about AT&T specifically. So that's it.
Up here. How much later do you think how much?
I emailed him and said,
Yeah.
you want me to sit here
Sure, wherever you
so I
like.
can do the moderator thing?
You wanna sit here?
Yeah, that's
Oh,
all.
yeah, of course.
Yeah, I emailed him. I emailed Kenny. And I'll say, we need to, I told him that you've got a flight.
Well, yeah, I apologize.
Just can't go too far behind.
I mean, I'm fine, I mean, but. Testing.
doesn't need to be. Right. But that's smart. It was triggered because in the past I've gotten letters saying, I am boom, 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 blah. And Mr. North has been invited to attend this conference. Outside there, and it's like sweet people. This is gonna be a really good one. Go to this one, not the other one. They'll all be coming up here. That was just the lunchroom. There we go. All right. Green light means you're on.
Green light means we're on.
Presentation.
Oh, you have a presentation?
Yeah, it's supposed to be on the presentation computer. Oh, you know.
Yeah, from the Dropbox.
Dropbox, yes.
Yep,
I
it's
got you.
all in there.
All right, cool. Just gonna move this out the way right quick. I did have to put stuff already. Okay.
So
Right
you
there.
are,
Four.
Yeah, he's the moderator, so.
We just hit play. Is there a play?
Should be, this is the,
is this a PDF?
Or is that it?
PowerPoint? Oh,
It's a PowerPoint.
Yeah. Okay.
oh, that's yours. Here you
That's
go.
Uh,
mine, yeah.
So,
This will
okay.
advance it.
Oh, here we go. 1, 2, 3. There you go.
Perfect.
And if you sit up there, you can also see it on those screens.
Yeah.
Too.
Appreciate that. Thank you for that. Thank you for that.
I'm about to email it out to everyone, so if you don't get it in like 5 minutes, let me know. Usually it would be out like.
So my first mistake of the day, I should have added y'all's names to this.
No worries, no worries.
Actually, it's probably not the first mistake of the day.
So,
Hello, checking, good?
secret just between you and me. Please keep this to yourself.
So you see the little green light over there? You can push it right off. Green light means your mic's hot.
I'm definitely having flashbacks of class clown days in high school.
Do you want to get, I mean, people will, I told everyone to hurry up and get in here, so do you want to start now or wait like 2 more minutes?
Maybe a couple more minutes.
Okay, that's fine. We'll route, yeah, we'll route.
Ring the dinner bell and
Yeah.
direct them in.
Is this all of us or are we?
I think this is it.
What's that?
Is this all of us or?
That's all we need.
Okay.
I think that's all we need.
What's all we need?
This panel.
Oh, yeah, we can just start talking. No, this is definitely all of us. And we'll finish at 2:15.
Yeah, that's fine.
Yeah, in fact,
All good.
will that, yeah, I'll just look at the clock. So as a reminder, I'm just gonna ask you to introduce yourself and tell us in your organization what makes a patent valuable from either prosecution and or enforcement perspectives. And, yeah, so we could do that. In fact, I may start with you, Jason.
Yeah, sure.
Come this way.
I'm happy to do that.
Okay.
Great.
And then, as we start going through the slides, like I said, I'm not gonna look at you and say, what do you think?
Right.
Every time. So I'll just pause and jump in as you wish. Thanks again for being here.
Sure, thanks for having us.
What do you think?
They're being crowd.
What's that?
People are being encouraged highly to come in, so,
Strongly encouraged.
yeah. Thanks for bearing with me on scheduling.
That's perfectly fine.
I've
Someone's going to the airport though, right?
Nothing on
It's like, this is the fifth. Probably. Do you want to take it back? You're welcome. Just like the holidays make you feel like a kid again. All right. Oh, thank you. Yep. Yes. I'm sending it out, literally have it in the Gmail with everyone VCC. Okay. It's gonna hit send.
My presentation
Oh, yeah, like on the presentation? Okay. Do you want me to add it to it? Yeah, I'll do that real quick. I should, it's probably in one of the buzzwords here, just tell it to me real quick and I'll. Sorry, say it again, Jay? Okay, that's fine, all right. All right, you want me to go ahead and get things started? Okay. Okay, everyone, welcome back. Jeff Keister from Taylor Duma is leading the next presentation. Taylor Duma is a sponsor of GLIPA, and Jeff has been, as you heard from Scott, involved in the Corporate IP Institute. I won't say again that you're a founding father, leave that phrase out of it. But I was just realizing that I've known you for almost 20 years since I was in a little adorable summer associate. So hopefully I'm still adorable, but I'm a lot more experienced than the summer associate. So, all right, Jeff, I'll turn it over to you, let you get started. Thank you for bearing with us again on the scheduled delay, but we're getting back on track. So go ahead.
All right. Thank you, Kenny. It's a pleasure to be here, and I'm particularly honored to be on this panel with moderating a panel of such great folks that are going to impart some hopefully wisdom and perspective today that'll help us all prosecute and enforce patents for greater value. So with that, I'm going to start with Jason on the end, and then each person will introduce themselves and talk about their company a little bit, and then the perspective of really what makes the maximum value patent from both a prosecution and an enforcement perspective. So Jason?
Great, thanks, Jeff. And by way of introduction, Jason Chang, I'm one of the in-house IP attorneys at AT&T, and I have the privilege of sitting on their patent department and managing the patent program. Before I came to AT&T, I was at Sutherland, now Evershed Sutherland, for roughly 7 years, doing mainly patent prosecution and some litigation support. And I've been at AT&T for the past 14 years. But this topic is actually very timely for me because I recently took over the patent program as of 90 days ago. So the question of what makes a patent valuable is very, very relevant. But let me take you through the history of our company. I think everyone is aware of the telephone, but what they may not be aware of is really that our company was started after the telephone patent, right? That was one of the first things that our founder did. And so I have this privilege of, being at a company that literally was started based on a patent. But let me walk you through what we've done over the years, right? So we start with the telephone. Think about the transistor, that was AT&T, the laser, satellites, Unix OS, recently audio video compression with MPEG. And most recently, I've written on my note sheet here, is disaggregated networks. And so as we think about the next generation of our innovation, here's how I think of valuable patents. And when I say it, it's going to sound very obvious to you, but I'm going to say it anyways. What we think is going to make a valuable patent are patent claims that cover AT&T products and services, industry standards, or competitor offerings. And in my view, that's all that matters, right? If you can get those claims correct in terms of mapping to one of those three buckets, at least from my perspective, we can generate value based upon that. And with that, I'll just kind of stop my introduction here and let Reagan introduce herself.
Hello, I am Dr. Reagan Charney. I started off my career at Finnegan, and then I was at Ballard Spahr after that, so I know a lot of you guys are familiar with one or both of those law firms. After that, I was at Newell Brands, and I was there for about 5 years.
I have been at ArcSada for about 6 years, and similar to Jason, I got promoted internally to be the head of IP for ArcSada. You have probably not heard of ArcSada because we are business to business. We are based in Switzerland, and our company was not based on a patent. It was named after a river. So our company started off as Lanza, and it's actually right by Novartis out in Basel, Switzerland. We make antimicrobials, which is what you have in paints and things like that to kill bacteria. So our company is highly regulated, so what makes a patent valuable for us is whether or not we can interplay between the regulatory and also the patent in order to maximize our protection.
Great.
Great. Hi, everybody. My name is Josh Meltzer. I'm the managing director for the IP finance group at Finitiv. I'm not a litigator. I have a finance background, and over my career, I've been working on really every type of patent-driven transaction, from spinning out patents from large companies and universities into new ventures, to joint ventures around strategic pieces of IP that spanned different markets. And most recently, I've been significantly involved in litigation funding. I set up 2 U.S. litigation funders, one out of a UK family office, one out of a US family office. And I'm currently with Finitiv, and Finitiv has a very unique program for funding high-value patent litigation. We have funded 36 cases representing over $300 million in capital. And we've taken a different approach to the process of funding high-value patent litigation. You may or may not be familiar with litigation funding in this context, but traditionally, litigation funding has been kind of held back, I would say, because the deals are very complex, they're very time-consuming, everything is negotiated and negotiable, and it's just disproportionately difficult to get these deals in place. So based on my background and some of my colleagues at Finitiv, and we took a different view of the market, and essentially we have developed a program that's based on some new ideas, standardized documents, standardized terms, very robust and standardized funding for the law firm, the litigation counsel, and $2 million to the patent owner, whether it's a university, a small company. So we have certain eligibility criteria for our program, and if a case meets those criteria and gets through our kind of multi-step, multi-party, multi-stage diligence process, then it gets the standard terms. So what we're trying to do is pull the friction out of litigation funding. And we have found that our approach really resonates not just with universities and operating companies, but really diverse patent owners that have the obligation and the need and the interest to defend their intellectual property. So what I thought I would do is talk a little bit about our process and our criteria, which is kind of a adjacent way to talk about how we think about patent value. So about 70% of our cases come to us from law firms. About 30% come to us from clients, patent owners directly, including universities. And we have to make sure they meet our criteria. So these are the investment criteria that we've laid out for cases that fit the program. We look for cases that have multiple patents involved in the infringement, so there's not a single point of failure or a single claim that we're relying upon. We look for cases that have multiple defendants, and the reason we think about that is it's risky and expensive and time-consuming to put a patent into litigation and validate that patent. And once we have achieved that validation, it's incredibly valuable for the investor to have follow-on investment opportunities. It's much more beneficial to have follow-on opportunities. Now, when I say follow-on, we don't fund the kind of cases where typically there's dozens of defendants or even hundreds of defendants. That's a certain profile of a case. When I say multiple defendants, it could be 2, it could be 3, but these are kind of large, independent, individual defendants. We spend a lot of time looking at the case through the law firm's eyes. So one piece of advice as you think about monetization or enforcement early on is it beneficial to actually have a litigator's perspective early on, even in the prosecution, even in some of the strategic conversations around patent prosecution? We spend a lot of time thinking about the narrative. Is this an innovator in this space? Were they doing breakthrough work in a particular area? Or is this someone who got a patent sitting in their basement and they believe it's a billion-dollar software patent? So the narrative is actually really important. And we spend a lot of time on our side in diligence making a distinction between the arguments that someone can make versus what they should make. We see a lot of arguments that can be made and that are permissible to be made, but we're trying to be good stewards of the process and the system. So we really, the whole story has to hold together. Just a couple other thoughts I'd share as context. We spend a lot of time going deeply into an initial case. We see 1,000 opportunities a year. We fund a tiny fraction of those. And I will tell you that a lot of opportunities that come to us, they come to us with a tremendous breadth of infringement. And that's not as persuasive to us. What we want to do is we want to go deeply into an initial case and confirm and convince ourselves with conviction that that case holds together. So we're less interested in defendants 2 through N and more interested in, does a single defendant really, once you start picking at the assumptions around infringement and the evidence and damages and prior art, does that hold together? And then once you have that initial case, then there can be a path forward. I'm just a few other points. We spend a lot of time thinking about venue and not just where the case can be brought, but where it can be held and where it can stick. We spend a lot of time thinking about that. So a lot of the arguments that you may be developing with respect to enforcement, they may play out differently depending on the venue. And a lot of times the arguments, if they're made in a vacuum, they may or may not play out as you expect in a particular venue. I just think this is interesting. We spend a lot of time from an investment perspective thinking about the tension between infringement and validity. We see a lot of opportunities that come to us where the patent owner wants to define the invention one way for infringement purposes and another way for validity purposes. And we really like to have kind of a coherent, consistent narrative around those two things. We like open applications. We like the idea that there's kind of, ongoing development of the portfolio can be really attractive. I guess the last couple things I'll say is, the way we structure our deal, and I'm happy to answer any questions, but the way we structure our deals is the patent owner puts an agreement in place, a retainer agreement in place with the law firm, and we put a funding agreement in place with the client. So there's no agreement between us and the law firm. We're not the law firm's client. The law firm's obligations are to their client, and we're essentially a passive investor. So each case that we fund gets roughly between $8 and $10 million. Of that $8 to $10 million, typically 3.5 to 4.5 is for hybrid legal fees at 50% of the law firm's rates. The law firm gets a 20% back-end share. The client gets $2 million non-recourse as part of the transaction, plus 60% of the recovery. And these are standardized terms. So we're trying to pull some of the friction out of the process. We're finding that a lot of universities, tech transfer offices are much more engaged in exploring litigation and litigation funding. And, I've spoken at Autumn, I've met with a number of groups, and I think they're realizing that if you are going to incur the cost and the time and the effort to build these portfolios, and you eventually hope to license these patents, when and if it's appropriate, you have to be ready to defend them. And litigation funding can really help level the playing field. And with that, I'll turn it back to you and pause.
All right, that's great.
Thank you.
Any questions from our other panelists or in the audience for litigation funding? It's a new concept that I think I agree with you, in some ways, game-changing. John.
Hey, Jeff, this is for Josh. Are there any subject matters?
Yeah, good question.
You want to fund, or ones that you think are really great? We have a bunch of inside counsel
Yeah. Yeah, it's a great question, and I would say I can't speak for other funders. For us, we don't make blanket distinctions around subject matter. We want to see good cases, and we've set up our process in a way that we know what we're looking for at this point, and we can filter things out pretty quickly. For us, it's more important that the patent owner has real conviction that they were an innovator in that space, and that when we test that conviction, it makes sense. So we work with a lot of universities, and they can not only just show us their patents in a particular area, they can introduce us to the inventor professors that were doing groundbreaking work at a particular point in time in a particular field. All that being said, particularly in our work with universities, we do tend to see a lot in biotech, in medical devices, in hardware and architecture and infrastructure. I mean, like just things that are more mechanical or physical. We certainly look at every software case we see. It's a high bar. We spend a lot of time thinking about the changing landscape around 101 and Alice. But I try and encourage people to bring us opportunities, and we'll do the filtering and screening on our side.
All right, great. That is a lot of enforcement strategy, and probably the bulk of the rest of the presentation is going to focus more on the prosecution side. So, Josh, thanks for walking us through your perspective, at least. Apologies for this not really showing up very clearly, but I'm told by Kenny that you're going to all get these presentations and have them so you can read them better. But the first thing I wanted to focus on was just getting your patents quicker. Just where are we on how to get a patent out faster so I can maximize royalties as soon as possible. Look at some of the 101 issues. Again, we've got 30 minutes left in this presentation, so there's probably a couple of hours worth of topics here that we could talk about if we wanted to. So I'll probably go pretty quickly through the information. Some claiming strategies, continuation strategies, and IDS strategies, and an inventorship issue at the end. So just in terms of fast tracking, you may remember that we had an environmental, energy, counterterrorism basis for fast tracking. They're all gone. There was also a design patent rocket docket option where you could push design patents faster. That's gone. The thing that's not gone, that's still free, is inventor age or health. And as I get older, 65 is not that old. And you may be talking to inventors that are actually 65 and you didn't realize it. So just asking, remembering to ask the question, is one of the inventors 65 years old? Or can we, one of our 65-year-olds, can they sit in on some invention meetings and maybe come up with some things? But the point is it's free and it's really fast. I mean, you'll get a first office action within a few months where otherwise you wouldn't. So, and the same thing with severe health. I think that's a typo. I don't think it was supposed to be severed health. Maybe it's a Halloween joke on me. So any thoughts or experience with any of these or questions? But just as, again, that's the one I forget about a lot of times is the 65-year-old. I don't think I've ever done a severe health. Has anyone done a severe health petition? One?
Yes.
Yeah, two?
And the nice thing about it is it lasts for the duration. Unlike an expedited examination request where you have to, pay a lot of money.
Yeah.
This is free and it keeps on going.
And speaking of that, nice transition. So the track one prioritized examination, it is expensive. I mean, large entities, $4,500. And then these are the other fees as well. But it is very fast, even for track one. So, 43 days from filing to petition grant, and then from petition to grant to first office action, month and a half. So, I mean, yes, it's expensive, but just as a reminder that it will go fast when you pay that higher fee. So that's really all I wanted to talk about, unless anyone's got any questions or other perspectives on moving things along. I think sometimes maybe you don't want to move things along very quickly. I think, Jason, you mentioned that. It really depends on the company that you're with and, what your product life cycle is and things like that.
Yeah, I would just mention that from an AT&T perspective, you think about our wireless products, right? Roughly a 10-year cycle. Fiber, wired internet, probably a 15-year cycle. It doesn't always make sense for us to expedite it. In fact, sometimes the delay is helpful where we want to see where the industry is developing. But we have tested, for example, based upon inventor's age, just to see how fast it would be and to have that in our back pocket, but we don't use it regularly.
Okay. All right, so 101, obviously we can't spend much time on this, but there's a few things to remember, focusing on how the computers and the technology improve performance. In some way, this sort of going back to Alice, does the computer work better somehow, or the technology technically? If you can get that into a claim, that is very helpful. Of course, there was that one case on internet-created problems. So if you can't really analogize it to a real-world situation, you just put that on a computer, or you're using a computer to make something faster that people would otherwise be doing, then that can be helpful. And then the human mind with pen and paper, unable to actually practice that. We've been on both sides of these issues, and it obviously depends on the court. There's still a lot of gray in this area, but those are still some of the things to just keep in mind. Any thoughts or questions on sort of the 101 issues?
I'll ask a second one, Jeff. It looks like the patent offices might be taking a more lenient approach with 101, but the Federal Circuit may still be taking a more rigorous approach. Do you have any thoughts on that?
Yeah, you're exactly right. There was just an announcement that with the new director that they're going to maybe try to bring more clarity, particularly in the AI space. And it sounded like not just clarity, but maybe they're going to be allowing more patents through. But then it wasn't more than a week later, some decision issued from the Federal Circuit. There was an appeal out of the PTAB essentially saying, yeah, we know you applied your guidelines and all, but we're not bound by those. That's not the law. So yeah, in some ways, it's not doing a good service to patentees when they're given these patents from the patent office that just are never going to stand up in court. So I don't like that situation, because we end up having to tell the client that, no, sorry, I can't believe you got this patent, but I don't think it's going to hold up. And of course, they don't like to hear that.
Yeah, this might be interesting just to give you the investor perspective. Sometimes we'll see a portfolio that has multiple patents, multiple claims, and they're subject to a 101 challenge. We know it's coming. And the law firm will, for lack of a better term, they'll have a strategy that basically is predicated on, well, not all the claims are going to rise and fall on the same 101 challenge. There's no single 101 argument that knocks all of them out. And that's really not persuasive to us as a funder, because while it may be true, it's challenging from a diligence perspective, because we don't know what actually is going to survive, what is going to come out the other side of that process. And we don't know the commercial importance, the infringement strength, and ultimately the damages. So while it's intellectually true that not all those claims are going to get knocked out, we don't know what comes out the other side. And that's very opaque from an investment perspective.
Yeah.
Even though we're a chemical company, this is something that we also struggle with, because some of our testing methods are novel, and they do involve a computer of some sort testing the antimicrobial activity or something along those lines. So our default has been to just not file, which is unfortunate, because it could be something that could be protected by a patent, and instead we just use trade secrets and licensing and things like that instead, because we don't know where the court's going to end up with these.
Right, and Congress also threatens to do something in this area, and if you don't file and you commercialize, then you're never going to be able to file, even though the law changed. So I get it, people are still filing, but I do wish that, I wish for a lot of things. Okay, claiming strategies. All right, so these are a couple of old things, and well, actually, these are all sort of old, but there is a new case on the last bullet point here. So, ideally, right, you want to be able to look at a product or a potential infringer and say, oh, yeah, I can see all the elements in the claim, right? You want to be able to detect. And so you don't necessarily want to claim things that are not detectable or you can't actually, you're not sure. Now, it doesn't stop some plaintiffs. They'll file anyway on information and belief that, they must do that, and you'll get it in discovery, but that's a lot to invest to not really know.
Yeah, we can't do that. We don't do that.
Yeah, I'm sure. 'Cause, I mean, you're putting a lot of money into it, so that, yeah. But so in terms of just a drafting principle, right? I mean, that's sort of a classic, don't throw things into your claims that you're just not going to be able to know. It's just, maybe that's something you keep as a trade secret. And then you focus on the other things that you do know, maybe you can get a patent on that. And then divided infringement, also, you probably remember Akamai and Centillion, and I think there was a case less than a year ago I was looking at as well, that further narrowed Centillion. So depending on whether or not they're method claims or process claims, method or apparatus/system claims, you could have divided infringement issues that make it such that there's just no way to recover. And if you try to get into, inducement or some of the other contributory infringement issues, you've got to have intent, which you may not be able to prove. So you're focusing on, one perspective, like if you're in a communications network, what's one server doing, right? Not what the other servers are doing. Or even if it's one server doing it, could it be split up into multiple servers that different parties are doing? These are things you need to think through to try to avoid, ideally, the divided infringement problem that's still out there. It's not something that kind of went away. There was some mitigation after Akamai, but it's still an issue. So again, you want to have something that's clearly detectable. You want to try to stay away from divided infringement. That's kind of on one side, get breadth and try to have, your claims be infringed by as many as possible. But on the other side is something I don't think many patent attorneys think about. I don't. I do now after this case again. I've thought about it before, but it's this perspective of what some companies call a licensing claim. And it's it's not a picture claim. It's not everything you can throw in, but it is from the perspective of what other products or elements are often sold with the system that you're selling. And if you can just get that in a dependent claim, you don't have to spend any time on it hardly in the spec, just because it's probably something that's old and the inventors don't really think there's much innovation there, so you don't focus on it at all or even put it in the patent. So that's what happened in this case that I wanted to talk about briefly, a case this year called Washworld versus Bellinger. And it was, as the name might suggest, it was a car wash system. And they talked all about different elements, but they didn't talk at all about the dryers that were at the end of the car wash system. And as it turns out, dryers are almost always sold with the other elements of the car wash system and were a big part of the damages. And so the district court didn't have a problem with it, applied the Panduit factors and allowed full damages, even though the dryers weren't in the claim or even in the patent. But the Federal Circuit reversed that and essentially reduced the damages way down because they had to get into the convoyed sales question of could you prove there was a functional unit for this whole car wash. In my mind, it sounds like a functional unit, but in their analysis, it wasn't. And so you obviously want to avoid this issue. And so it's it's the opposite of I want the broadest claims I can possibly get. It's actually what else could I actually throw into my patent, even briefly, just to increase damages. So I don't know if anybody's got any experience with that or any thoughts on that, but it was a good reminder to me when I read the case that, oh yeah, even the prior art stuff that's not part of really the innovation, it's just other things that are sold typically and therefore will increase the damages.
This is maybe an adjacent point, but I want to also mention that we think a lot about the infringement in the context of claim construction. So if we're looking at the infringement read and we're evaluating the claim chart and we see that certain terminology, you're just going to have to win a whole nother battle on claim construction, that's something we think about, and obviously that just factors into our assessment of risk. So if your infringement read is predicated on some achievement with respect to claim construction, that's going to be something that a sophisticated funder is going to understand and be concerned about.
Okay. All right, moving on. Continuation strategies.
Let me just chime in, because we did talk about this before, but.
And interrupt me anytime, because I'm just going to keep pushing.
So with system claims, what we think about as well is patent marking, right? Is how many of us actually do it? I will fully admit that as a company, we don't do it, but I've been questioning whether we should. And so I kind of just raised that point of, if you want to go after system claims, should you also consider marking, as part of your products as well?
Yeah, absolutely. I didn't have marking as one of the topics, but to maximize damages, it's definitely one to keep in mind. And of course, there's virtual marking available under the statute, but how do you mark a system, right? Can sometimes be very challenging, but giving some thought to that, I think is very important. All right, continuation strategies. Obviously, from a funder perspective as well as others, having a continuation pending when you go into enforcement is so valuable, right? I mean, if you've ever been in that situation where the accused infringer just, designs around and case over, right? But if you've got a continuation pending, maybe it's a little bit of a cat and mouse, but you pay that extra fee to expedite, and now you've got claims covering the design around. So that's obviously helpful. There's another issue that's come up from time to time with prosecution disclaimers in a parent. So during prosecution of a parent application, there's a response that says, this claim element is not in that piece of prior art. That technically can create a prosecution disclaimer that claim element does not cover that piece of prior art or anything like it, right? Well, that's going to continue into the continuation as well, unless you rescind that prosecution disclaimer in the parent. And so that's one of our common practices, is we just, as a matter of course, will rescind those disclaimers. And so I think Hakeem versus Cannon was the case, if you want to see the impact of that. It was a sippy cup case, if you'll recall, where the little diaphragm inside the sippy cup lid was a slit, and the parent claimed the slit in the diaphragm, but then in the child, they claimed opening. Okay, so it's broader, and the court ended up saying, well, you didn't rescind that disclaimer from the parent when you distinguished the prior art with slit, so we're going to interpret opening to be just a slit. So again, and all you need to do is just tell the examiner we're rescinding any disclaimers in the parent. So it's and maybe say what the disclaimer might have been. That's sort of one practice. So whether or not you still need to do that, I think it's a good belt and suspenders approach. But there's this new case that's come out where there was different claim terminology that was used, and that's McKay versus a Biomed from this year, where it was a larger patent family, had a grandparent application even, and there were some earlier statements made in prosecution in the grandparent or parent application, and there was an attempt to have that also apply in the child applications. But the Federal Circuit ended up finding that since the claim terminology changed from the parent application to the child application, that was enough to essentially get rid of the prosecution disclaimers from the parent. So in this case, the 238 parent said entire elongate lumen distal to the pump. The same element in the child was instead characterized as a guide mechanism comprised a lumen. So you can see it was essentially the same structure. They just used different words to describe the same structure, and that was enough for the court. So if it's like in the sippy cup case, if it's like opening versus slit, maybe that's not enough of a change. That's why I think maybe the rescissions might still be useful. But if it's a more substantial, several words are different, and you can see how easy this would be, especially if it's, again, an element that you said was not in the prior art in the parent. Just think about changing the words in the continuation so that you can automatically get around any claim prosecution disclaimers in the parent. All right, any questions or comments? All right, information disclosure statement, we're moving along. You may be aware if you're if you often have larger families of continuations, for example, the IDS rules changed at the Patent Office where they now charge you for more references being cited. So if it starts at 50. So if you have 50 references being cited in an application, you pay money. And then if it's more than 100, and it's more than 200, and it's cumulative. It's not one IDS, it's cumulative throughout the prosecution, right? So the Patent Office also reminded us, nice of them to do this, that you don't have to cite the references that were considered in the parent case. So to save on these fees, they were just reminding you that you don't have to cite them. The examiner has a duty to look at everything that was in the parent or previous applications in the family. So you can save money on it, but I had an initial question of just, well, I might still like to have the reference on the front of the patent so I could hold it up to the jury and say, they're trying to say this patent's invalid, even though look right there, the examiner considered this reference, rather than saying, well, the examiner had a duty to consider this reference. Just makes it a little more of a better story if you do cite those references, but you're going to pay for it. So that's one thing that's affected some strategy. And then the second thing is there was another case that involved a discretionary denial in an IPR where they reminded us that, or I think actually changed the rules and said that there could be a denial of an institution even if if there's no evidence that the examiner actually considered the reference, like it didn't show up in an office action as part of a rejection. As long as it was in the record in an IDS or something, then it was before the examiner, and that's going to be good enough to make it more difficult for the IPR to be instituted. But the other issues in this case also created some other problems. So Ecto World is the name of the case, and it was a discretionary denial review. And for those who are not familiar with discretionary denials, this is something that's also brand new. So the previous interim director, who's now, I think, the deputy director, is continuing this discretionary denial process where when an IPR is filed, the director, because of DOJ cuts and expected reduction in PTAB judges, could simply discretionarily deny the institution of the IPR kind of for any reason that the director thought was appropriate. And so one of the bases, for example, is if the patent is more than, say, 5, 7 years old, or maybe less, it seems to be changing every day. It started off at 12 years old, then there are what they call settled expectations for that patent now, and no institution of the IPR just because it's an old patent. So things like that, or references were considered already, that's enough. And that's why this is in the IDS section, because if you get more references before the patent examiner, then it just decreases the chance that you're going to have to fight an IPR. And so there's motivation to send more references in, maybe do patentability searches where you didn't do them before, because your patent's going to be stronger just having the references on the record as part of the IPR, and you may survive. The IPR may just be thrown out right in the very beginning. The problem in this case, though, was there were over 1,000 references cited. And so the director said, okay, in general, if it's in an IDS, no institution, but unusually voluminous IDSs, that may be different. We're going to have to look at that a little bit closer. So maybe a few more than you're citing right now, just not too many. And then the other thing is something that will show up in office actions a lot of times is the examiner notes that there are many references in the IDS that the applicant cited. Applicant is requested to identify the ones that are particularly relevant in this examination. I don't know if any of you have seen that note in an office action, but they do occur from time to time. Don't ignore those, because that's what the director noted here as well, is that if you just don't give them anything on that, that's not good form. You don't have to, they're just asking. If there is anything particularly relevant, let us know. Well, you might want to at least respond if you get one of those. Any thoughts on IDSs? Cool. No? You do, you? The silence, no one wants to jump in. Like, I got one, Merle, yes, brave Merle. Yeah, I'm still citing them, maybe with good point in that, and I guess I'll cite them once in the parent, but then after that, I'm not going to cite them in the continuation.
Yeah, that's the hard thing with this, is that you can save money by filing a smaller IDS, but then it makes your patent weaker. So it's kind of this
Yeah.
save money on the front end, but maybe spend more on the back end.
Yeah, and so maybe you get, 50 to 100, but not, over 100. I don't know where the sweet spot is on that, but it does create these sort of competing interests.
Yep.
All right, I think the last topic was going to be inventorship. So as Josh mentioned, funders pay particular attention to a lot of things, and one of them in particular is inventorship. Because as you might be aware, if there's some inventor who comes up later, hey, I was also an inventor on that patent, it could create issues, right, in the litigation. First of all, if your employment agreement is not in good shape, if it wasn't signed, even if your employment agreement says they shall assign and doesn't say hereby assigns or hereby assigns as soon as they invent or whatever, the company may not own that inventor's, contribution aspect in the patent. So now that inventor's a co-owner of the patent and can license to whoever they want to license to. So your patent is arguably worthless if there's a missing inventor in some cases. And then even in the due diligence situation, like an M&A, there was a case not too many years ago where a patent law firm got sued for malpractice in an acquisition due diligence situation where they didn't do a deep dive into inventorship. And it turned out that the patents were really the value of the company. There really wasn't much else. They were the primary asset. And so when you're doing your due diligence checklist and going through and saying, are the inventors accurate, you might want to talk to some inventors. So are there any other potential inventors out there? Could anyone say, I contributed to that idea, and they left me off? Those are questions that need to be had even in prosecution, right? Don't just necessarily take the inventor's word for it who volunteered and said they were inventors, right? I mean, the critical question is, who else might say they're an inventor that's not listed here? We really need to have them on this. And then, of course, you get the assignment from them and take them off later if you decide that they're not inventors or if the claims change where they're not inventors. But it's obviously best to have that assignment if you can get it.
We spend a lot of time on this, and we see a lot of opportunities that are not transactable because of this, that they potentially would be transactable on the merits, but there's a loose end somewhere or an agreement that we can't get our hands on or our eyes on. We're just not really going to take the risk of trying to litigate the case while we're trying to litigate a dispute amongst inventors and potential inventors. It's not where we want to be. On a related topic, we also spend a lot of time on assignments, the chain of title, the history. It's really important. We don't want to be finding stuff out at the same time the defendant is finding stuff out with respect to a case that we're funding. It's particularly relevant in the university context where there are different funding models or the quasi-government funding context with DARPA, and in Israel there's the Office of the Chief Scientist, OCS. I mean, you just have to figure these things out in advance, and you don't want to be putting down the track in front of the train, in terms of a case you've already funded. So it's a really important part of our diligence, and a lot of deals fall apart on this issue.
Yeah. I'll speak from a big company perspective because some of the suggestions here truly scared me, which is, law firms asking who else should be involved. I would say when you have 140,000 employees, as we do, that's typically a question that we don't necessarily love to ask because I think inventors, honestly, don't always get it right in the first place, right? They list their team members, they list the entire team, and we have disclosures with, 15 inventors, right? It probably should be a lot lower. But I would tell you, we would be in line with the points we discussed here because my point is that unless every single inventor agrees, we're not going to take anybody off. Everybody on that list who was named the first instance is going to be a named inventor simply because I can't take the risk that we take somebody off And then now there's a record that, oh, maybe this person should have been included. Why weren't they included?
Yeah, we do the same.
Same thing?
Yep, if they're listed, even if we maybe are like, we'd rather get the assignments and have everything buttoned up and then file with that person.
Yeah, absolutely. All right. Questions from the audience? I think we accomplished our job of staying relatively on time with a little less time. So any questions out there? Yes, Merle.
Josh, I wanted to know about diligence or validity. How do you address your concerns about validity of candidate patents?
Can you repeat the question?
How do you address your concerns about validity when you have a candidate patent? What diligence do you conduct about it?
Yeah, good question. So this is a topic we spend a lot of time on, and I would say that to start out, the entire narrative has to make sense. So for example, we don't necessarily put a lot of weight on generic prior art searches, right? So prior art searches have the most utility to us when they've been done in the context of the litigation that's being envisioned, right? So with an understanding of kind of the scope of the litigation and with an understanding of the infringement, like it's more, I guess what I'm trying to say is it's very difficult to boil the ocean from a prior art standpoint, and we don't expect our counterparties to boil the ocean from a prior art standpoint. It's more persuasive, and this is just our point of view, it doesn't mean we're right? We just have to take a view. We find it more persuasive for someone to say, this is how we've defined the universe of prior art as it relates to the litigation. And as a result of that, these are the key references that we think are really close or that are going to come up. And obviously it's well beyond what's on the face of the patent, right? It's with the benefit of the litigation as context. So, I tend to, if I'm asked, I tend to dissuade the notion that you're going to create this comprehensive boil the ocean prior art report, because that's just elusive. It's just really difficult to do. So we do require a prior art search to be done, for us to fund a case. It's part of the submission. But we get the most utility out of it when it's been done in the context of the litigation. And then we have resources that look at that work product and also do kind of adjacent searches to get comfortable. Is that helpful?
It is. You find a reference that they didn't find, have a continuation.
Correct. Correct. But I mean, we're trying not to impose like false precision on the process, which actually brings me to a point I was going to make when the opportunity came up, but this is a good juncture. There's a huge distinction in our mind between a riskless case and an investment quality case. We're not looking for riskless cases. We haven't seen a riskless case yet, right? So if you have one, you have a unique situation there. So we're not looking for riskless cases. We're just looking for investment grade cases where we can understand the risks, we can understand how they're likely to play out. If we were looking for riskless cases, we wouldn't be deploying any capital.
We haven't.
Same. I don't spend a lot of time worrying about what might happen, to be honest, because I've been around long enough to see where that goes. I hear there's a lot of opposition in the industry as well on that tax.
Yeah, and just to elaborate, we don't worry about it either. It goes more to our company's valuation in general, and so we would rather file patents and have our company be valued higher. We're private equity currently, so there's probably something in the future where we'll get sold or spun off or something like that.
All right.
I have one question for Josh, actually. In terms of continuations, I know you mentioned you like having open families. How do you manage the risk that you might get something bad and actually make the family worse in a continuation versus the optionality that it provides?
I'm not sure I have an answer to that. I mean, I'm not sure I've even gotten that question before. I would say that generally speaking, on balance, we view it as positive. I would say that we're in touch with every part of the system, meaning sometimes the law firm is handling both the litigation and the prosecution, and there's coordination, even if it's a different firm that's doing prosecution and/or IPRs and the litigation firm. I mean, it's just making sure that everyone's kind of working towards the same goal. Keep in mind the funder is passive. So actually, that's an important point to mention generally. The funder is passive, so we're not the client. We're not making those decisions. Ultimately, the way the funder operates is we set up a set of terms and economics where everyone's interests are aligned, and that if the patent owner does well, we do well. So we're not directing anybody to do anything in terms of what gets filed or what doesn't get filed. We're hoping to partner with sophisticated parties that make rational decisions. That's the best I can give you on that hard question.
It's a good place to be.
Mm-hmm.
All right. Thank you.
Start in about 15 minutes.
This is a nice open.
Thanks so much, Josh. You go, Josh or Josh? Josh. All right. Yeah, I appreciate it.
Yeah, we would, I was gonna just sit over here, just, but I don't think it matters. She was leaving here for an hour to take her over to tennis. So she was. Green means you're hot. Green is hot. Yeah. Oh, yeah, what you got? What you got? It should be loaded on the Dropbox. I believe so. I don't know. Can you see it? No, but like on your screen. Yeah. I see it's like session 5. I can open it up right quick and see what happens. That's you? That's me. All right. And where is the? You got it. Okay, cool. Go ahead and do a test for me right quick. All right. That responding for you? Is that okay? All right. Okay. And we're going public. There you go. All right. Great. Thank you. No, you're welcome.
You just happened to be in my field of view as I was walking into the circle. Y'all ready? Oh, thank you. Y'all like some waters? Oh, you guys got some? Okay. Those look cold. Thank you so much. Okay. Welcome back. So my claim to fame with this panel is mostly, well, I'll say it starts with AUMA, because back in the day when I was in entertainment practice, I worked for a small boutique firm, and we had outside counsel handle all of the trademarks for many of our clients. And so I had the honor of working with AUMA, who is one of the best attorneys I know, and also one of the kindest and nicest people. I love seeing her all the time. Sorry, you didn't know that was going to happen.
No, I'm like, I'm already starting to get emotional.
So I'm always excited when she is here. And for Mike and Andy, I don't even really know these guys. Who the hell they are? I'm just
showed
kidding.
up.
Yeah. So well, Mike, I met on my that big conference back in the Dominican Republic a couple of days after I had gotten admitted to the bar many, many, many years ago when I was young. And you know I was young because we went and celebrated that night after getting admitted, and then I missed the flight to this CLE conference the next morning. I'm a much different guy. I'm not trying to embarrass I'm going to just stop talking. Mike, go ahead. He's a really great attorney too, and Andy has been at SIPI a few times, and it's really good to see you as well. So thank you guys for doing this. I'll turn it over.
Okay, thanks, Yanni. Appreciate it. Okay, so the topic of our panel today is From Brussels to Bangkok, How to Protect Your Brands and Creative Content Without Losing Your Mind. So this is your own little passport. We're going to go on a little trip today. And in the context of trademarks and copyrights, that intellectual property portfolios increasingly are growing globally. The sophistication that's required to deal with the global portfolio is providing a lot of challenges for in-house counsel and also for outside counsel at the same time. And so what we're going to try and do here is highlight and identify and flag some of the issues that you're going to see in these specific areas globally in these areas. Now, a couple things, and we were talking about this a little bit earlier, that first of all, a couple of y'all may be thinking, not patent? And the answer to that is not patent. But our thinking along the lines of this is, first of all, if you are, and your specific title and responsibility is patent, if your trademark person is out on vacation, which trademark people are out on a lot of vacations. So if they are out on vacation, who becomes the trademark expert? You do. So it's really one of those things to be able to identify and issue spot and flag. That's very important and something that you're going to want to know. I would say also that one other thing you won't hear, so you're not going to hear about patents, but you're also not going to hear the dreaded words soft IP used here. They are just anathema and just make my mouth taste terrible. So we are not going to use soft IP. I think that we can all agree there's, well, I'm telling you not. It's a big international no. So it is. It's deeply offensive. What we prefer instead is shredded IP. This is, you are going to be pretty buff at the end of this, this seminar. You're going to be all set. There's going to be nothing soft about you by the end of this. So with that, I should, just one last housekeeping. We do have a time for questions on our agenda. You'll see that, but if you have questions, obviously raise your hand and we will get to them and do our best to go ahead and answer those. You'll see here the agenda. I assume y'all can read, so I'm not going to go through that, and we'll move forward. And to the most important part, Kenny gave a little of this as a preview to begin, but I'm very, very excited about having the two panelists next to me for this particular seminar, that these are two experts in this field, not just in Atlanta, not just in Georgia, not just in the Southeast, not just in the United States, but literally international experts in terms of this space. And so I'm very honored to have them here, and I know that you'll get a lot of information by having having them here. So briefly, my name is Mike Hobbs. I am a partner at Troutman Pepper Locke. I have to keep adding on to that name because we apparently found some lawyers who did not practice with us. So we merged with them in January, and we're keeping an eye out. Apparently, there's still some lawyers out there, but keep tuned for what the next name will be. But at the end of the day, it's just yeah, Franklin, right, exactly. So for the moment, it's just Troutman. And I do get people ask, and they're like, oh, Troutman Pepper Locke, isn't there a firm Troutman Sanderson? And then I have to go through the explanation. It's just one of those things. So let me provide the additional explanations, introductions. Uma Reggie is truly one of the best people I know, both professionally and personally. Her job title is the Managing Chief Counsel of Intellectual Property Legal Team at McKesson Corporation. McKesson is ranked 9th in the Fortune 500. I don't mean like 90, I don't mean like 59, I mean 9 in terms of that. So it is a very, very serious company. It's a healthcare services company and information technology focused, dedicated to making the business of healthcare run better. As the head of IP Legal, Uma leads a team that supports global trademarks, copyrights, patents, trade secrets, domain names, digital marketing, ad tech, right of publicity, online brand protection, and anti-counterfeiting, and I assume recently over the last couple of years, AI. So with 25 years of experience, her career spans private practice at law firms, government, and worldwide legal corporations, including a decade secondment and a national quick service restaurant legal department. And over and above this, and I think this is probably what you'd have to pry out of Uma, but she is on multiple boards, including INTA, US IPA, and the Kenya Project. She was recently honored with the Lifetime Achievement Award from My Sister's Keeper Foundation for Women, which recognized her leadership, extraordinary dedication, passion, and excellence in the community, industry, and society at large over the last 20 years. So honored to have her here. Thank you, Uma. Also next to me is Andy Weeks. Andy is the Senior Director of Legal Counsel Trademarks at the Coca-Cola Company. You may have heard of that as well. In his current role, he provides global trademark legal support for many of the Coca-Cola Company's brands. And prior to that, Andy was an associate at Kilpatrick Townsend Stockton, where he focused his practice on domestic and international brand management, including trademark prosecutions, clearance, strategic management of global trademark portfolios. Hence him on this panel. Andy received his undergraduate degree from the Atlanta College of Art, his graduate degree at Pratt Institute, and his JD from the University of Georgia. Before attending law school, Andy taught art and art history and was a working artist with a national exhibition record. And he lives in Atlanta with his wife, Elizabeth, 2 children, and a dog. And I would add, just in terms of that, sometimes you hear people and you think, oh, artist, in terms of this, and you think about your aunt who paints cats. Andy is a really, really serious artist, that he is unbelievably talented. And I'm going to embarrass you, but put a plug. Instagram site the best site for viewing your portfolio?
That's right. I'm here for a reason.
So it's really, and I'm always, one of the things I like about intellectual property is the opportunity to practice and to have relationships with people who are practice and who are content and care about content as much because it's really mattered to them. So as you can tell, we've got 2 great experts with us today. So what are we here for? So here's the objectives we're trying to go over. The first is trying to flag some areas about differences in law and IP law and really get away from kind of a US-centric view of things. I think that unfortunately, whatever the case may be, whether it's food, politics, and law, people think, oh, it's just like America. Well, it's not just like America, that if you go internationally, particularly with intellectual property, there's some real significant differences, and you got to take those into account. The expectation is you are not going to walk out of here an expert in the IP law of all 190 countries. 189 maybe, but no. The goal is not for that. The goal is to be able to issue spot and say, hey, look, I know that there's some differences here. How do I take that into consideration? And knowing that, what strategies do I have and what can I bring to my organization or to my clients for international protection and enforcement, and then some practical tools, whether they be via treaty or IP global management. So before we get started, anything, Uma, you want to bring or discuss overview?
No, something you said about, I was just jotting down, you said, this will sort of be, think of your IP strategy as a passport, and I wrote down, a passport should always be valid, well-stamped, and ready for travel, right? And so that's sort of like we sort of have to stay ready in this space. Things are changing constantly. Things are changing constantly internationally. And so I just like the way you phrased that as sort of having your passport ready, and hopefully all of us will have our passports ready.
Excellent. Andy, thoughts?
I wrote down the same thing.
Did Uma copy off this?
Yeah, I think she was looking over my shoulder. No, I don't. I would just say, I would just reiterate that my hope is that the session that we're doing is like practically valuable to you, and is, it'll be like kind of high level helping you identify issues.
Okay, so the first of the areas that we wanted to hit, and this is one of those ones where we said we're not necessarily going to go into a lot of substantive necessarily on the specific laws, but this is one of these overarching principles that applies to the work we do globally in particularly the trademark space every single day. And if you are a trademark attorney, in large part, you may already know this, but if your practice is domestic, it's good to consider this. And if this is not your particular area of expertise, it's good to have this tucked away that you may have taken a survey class with that had patent, trademark, copyright, and you got very quickly about, oh yeah, use is required. That's what we've got to have a trademark. That's in the United States. The United States is really the exception to that. So in the United States, you have an existence of something called a common law trademark. If you use a mark, you have rights in whatever your geographic trade territory is. If you get outside the United, and I should add, Canada has the same laws. Pretty much everywhere else in the world, whoever files first, and that's the priority. That is who is going to own the trademark rights in that mark. And there is no such thing as a common law trademark. So what does that lead to, and what does that mean? Well, there are some examples that I took a look at just briefly. And so, for example, Apple had to pay $60 million to be able to purchase the iPad trademark in China. Tesla had to settle with Zhang Baosheng for the Tesla trademark in China. Think about what that was worth, and that was a confidential settlement. Starbucks was not able to enter the Russian market because they didn't have Starbucks registered in Russia, someone else did. And the PlayStation 5 was delayed in India, which you think about a huge, huge market for them. They weren't able to enter there because someone had registered PS5 in India. No use, no requirement. And there was a period of time, it seems to have diminished a little bit, but it always is sort of migrating, that I felt like there were certain countries in South America where the Christmas gift of the year was a trademark registration, because it just, every time we tried to do business or tried to clear a mark or do something, or God forbid the client launched thinking, oh, we own this mark in the United States, we must be okay in Peru or Ecuador or Bolivia, and they weren't. And that was just a very, very tough to explain to the clients. No, it's a first to file. Someone else filed it. Oh, what's their use? They're not even in business. Right, exactly. So those are some examples. I don't know if you all have some ones that you want to add or thoughts about first to file. Maybe Uma? Or,
Yeah, no. As you were saying that, I was thinking, so we'll talk a little more about sort of strategy, overall strategy, and I always sort of put it into the what, the where, and the how. Of course, we'll talk in more detail about what those things mean, but the where, right? So the first to file versus first to use. I think the first to file systems are not understood. It sounds obviously intuitive, it's the first entity to file, but invariably a lot of times people are not as in tune with what those countries are. There are many, as Mike said. I think of, in particular, and again, I'm not speaking on behalf of my company, but sort of just generally, I think of particularly manufacturing activity and supply chain. And when you are in a scenario where a third party is manufacturing on your behalf, so typically that's in the contract manufacturing, style approach, you need to be thinking, somebody is locally doing something for us, potentially branding products with your mark. Think about the first to file countries where that could be happening, China, I believe India as well, and many others. So, a lot of times, we'll dig into this some more, but it's really thinking about your strategy more holistically. And some of those, I'm just pointing out a place where I see some people have a deficit. They're not thinking about those third-party partners, vendors, and others who might be doing activities on your behalf in other parts of the world.
Yeah, and another thought on the first to file versus first to use. Maybe a couple. One of the thoughts is that for a global company where a lot of the employees are familiar with trademark law in countries outside of the United States, they may be surprised to learn that there's a first to use requirement in the United States, so that they'll think, well, why don't we just file for this mark that we own in our country, not understanding that it will not go anywhere without us putting some use in place. So that's one consideration. Another, it's a balancing act, understanding that there is this first to file requirement. You want to protect your mark as widely as you can around the world, but then you also have whatever budget constraints you might have, right? So it is important to have a strategy there. It might be that you have identified like a top, and by the way, I also do not speak on behalf of my company. I'm sharing my own point of view. But you might want to identify a set of priority markets that you recognize as essential, as vitally important that you're able to use this brand, even if maybe you're not yet there, that you look at. And you might also want to look at countries where you kind of can anticipate that as soon as you file in the United States, someone's going to file there.
We were discussing about earlier that one of the things, how many of you all have gotten a notice, you filed a trademark application, and then you received a notice, or one of your colleagues or one of your clients received a notice that we are alerting you to the fact that in China, this exact mark is being registered, and we're alerting you so that you can take immediate action with regard. Show of hands, how many people have gotten it, or clients have gotten it, or, okay, you all are better. I get this hourly. I mean, I literally have an email that just says, you're correct, this is spam, this is not, because they're monitoring the U.S. Patent and Trademark Office database as a public database, and there are people who monitor it, and then they will make decisions. So even, as you're thinking about, oh, we're launching in the United States, we've got our application filed, what are you doing globally? And the issue becomes pretty quickly that you start to realize that I tell clients, back of envelope, $3,000 per mark, per country, per class. Can be cheaper in some countries, can be more in some countries. And they start going, okay, how many countries in the United Nations? 190. Uh-oh. And so there is no way you are filing unless it is the peak top brand. So then you have to start saying, okay, what are we going to do and what's the plan on this? And there's not necessarily a right or wrong answer. What it is you're trying to talk to your business folks about saying, okay, you realize if we don't file, we are potentially liable, and we're going to have issues with pirates in some places if we don't do something. But at the same time, we can't file everywhere unless we have an unlimited budget, which I have never seen before. It is elusive. So it's definitely something to consider. And I think Andy's point about also coming back in terms of it, that if you have inbound work and you have clients who are thinking, who are globally, and they're thinking, oh, I'm just going to extend my international application. Well, what happens in 5 years when you have to renew it? They're left and they're like, well, we just, we have to show use? And they're like, yeah, use, like a picture. You have to actually show use, and you have to attest and sign a declaration that it is in use. So the back and forth between the two systems is definitely something to consider. These are some other things just talking about, and the consideration, some other add-on effects of having the first to use and first to file. One of them is that we talk to our clients and we say, okay, you consider doing a defensive filing. Even if you're not going to use a mark in China, do you file for it? Even if you're not going to use a mark in India, do you file for it? Because they're very big markets and they potentially have issues. Well, what happens in the countries is that if you haven't used a mark for 3 years, you are subject to, and anyone can file a cancellation action for abandonment and non-use. So you start to realize that, is this just like one big bridge painting exercise? Because if you file 3 years down the road, it's subject to a charge and a claim for cancellation, and then you realize, oh, we got to file another new application. And then if you really take it out, for some countries, the pendency of a trademark application is 5, 6 years. And so you're saying, do we now have queued up trademark applications? Again, I'm not trying to present problems. What I'm just trying to do is present issues. And if you say, okay, we're going to file in these countries. We're going to realize that we're going to file these defensively, and that's going to be part of the plan, but that's what we're going to try. So anything else about first to file?
I just, not specifically first to file, but about costs. And I had a really good conversation yesterday with one of our colleagues here about sort of, whether cost should be, and we weren't saying it should, but, there's sort of a perception that cost a lot of times is the primary or sometimes sole driver of decision-making. And I always say, if you start with cost sort of as the decision maker or the significant aspect of your decision-making process in terms of your strategy, things are not going good, right? Like, I think, and again, we'll talk as we go through the session about some considerations even before what this thing will cost, because there are instances in which you will throw all your money toward a filing program. And usually that's, your sort of flagship marks, your company name, right? Brands that are used across all product and service lines. So, sort of those core marks. And then there are instances where you're like, you know what? This is limited time offer. We're not even going to, sort of take, sort of give much significance to that filing. But I just say, again, cost, I love to talk about it because a lot of times people sort of throw their arms up when they hear how much money it will cost to file in all of these 100 and so, maybe sometimes 90 countries. Well, of course, nobody is just, just all this money sort of sitting around just for trademark filings or copyright filings. But I do think that should be sort of taken into consideration around, like, is that sort of your primary driver? And if it is, sort of rethinking that strategy as well.
Andy?
Yeah, and one other thought on first to file, which is just that, one solution to the problem is to spend a lot of money to purchase that mark, which of course is not ideal. Another solution is also, in some instances, it might work to just make sure that you're like in good, for those of you that are in-house, to communicate with your business partners and make sure they understand this potential issue, and that in some cases, even instead of buying a mark, there's flexibility where maybe there's an alternative mark that kind of does the same job, and despite the existence of this other mark out on a registry somewhere. One example I can give, like the AHA brand, which is a Coca-Cola brand carbonated water product. In China, if you go there, that product appears as AH exclamation mark, HA exclamation mark. It sort of threads the needle.
Yeah, I think it's one of those ones that to have that dialogue and to have a plan, it becomes and most companies do end up with this because of the cost, but I think it's the plan in addition. But first of all, everything that you file for in the United States, you just cannot file for globally. You cannot. It just is just going to be so costly to do that. And the reality is the product may not be in all marketplace. And so to try to tailor that, because the one other thing to talk about cost is that there is the cost of the filing, but that's a percentage in terms of the overall cost of what it's going to cost to prosecute. And then one of the big tails that we see in terms of trademark is renewals. And so there's always that, renewals become that, every country has a specific renewal period, whether it's 5 years or 10 years or whatever the time period is, but you got to renew it. And so then you go to someone in the business unit and say, hey, do you want to renew this? And you have to find someone who can definitively say yes or no. And the default, and we were talking about this the other day, is the default tends to be just renew because there's no use requirement. And so people just renew it. And then it becomes, wait, why did we renew that? At some point, someone new comes in and goes, wait, why are we renewing this? We haven't sold this product internationally in 10 years. And it's like, oh, okay, well, that was a few dollars we might have repurposed.
And don't forget the foreign associate fees.
Exactly.
Which can be hefty.
So we want to give a little bit of time also to copyright. And copyright is a different animal for a couple reasons. One is that in the United States, you do not need to register it. There is, and as most people know, you can register copyright. There's some significant advantages to register in the United States. If you want to file litigation, it's a prerequisite, jurisdictional prerequisite to have a copyright, not just application, but registration. So there's some aspect about, okay, if you wait and then you've got to file an expedited copyright application because you got to file a lawsuit. Okay, what happened there? Would we have been better off filing earlier? And also, if you want to be eligible for statutory damages, you have to have a registration that is existing prior to the infringing occurring. So I usually tell people it's a bit of an insurance policy that I don't purchase insurance on everything I do in my life. I don't purchase insurance, although maybe with TSA now I should, about a flight insurance on a specific flight, or I may not purchase, a warranty on my laptop or some of the other things, the underguard rust coating on a car, but I sure as heck purchase life insurance. So with the copyright, is this important for your practice? The Berne Convention, and that was a terrible pronunciation, but I didn't want people to say he was talking about Bern, like go for the Bern type of thing. No, it's the city in Switzerland, obviously. It's approximately about 120 countries are signatories to the Berne Convention. The Berne Convention provides that if you're a national signatory, you have to give the same protection to works from other countries that are signatories that you do to your own citizens' works. So the upside is it can be very valuable to gain protection. It's not perfect, though, because there can be gaps and there can be advantages and reasons to file globally. Couple things, and I'll just hit a couple of them right here, is to keep in mind that the copyrights are not all the same. One example is the term. So the United States, for example, the term is life of the author plus 70 years, or if it's a work for hire, it's 95 years from date of publication or 120 years from the date of creation. And I will give you a tip, if you get nothing else from this, go to Cornell's website. They have a really good chart that I still use because it was created in 1928. Was it renewed? How many renewals did it have to file? Did it actually have to be registered? All of that. But under the Berne Convention, other countries only have to give 50 years. And so if you give a lifetime license to a content that's something that's copyrightable, what are you actually giving in terms of the country? There's some other laws that are different that are, I would say, copyright adjacent in terms of the United States. You have fair use. Most people know 4-factor test. It's a very flexible, how much of the work is used, what's the purpose, what is it do to the marketplace, and the nature of the work. And that's a very fluid factor. Most countries other than the United States don't have that. The only thing that they have is they have very specific treatment of moral rights. You're entitled to attribution, you're entitled to integrity, you're entitled to a number of other factors. But if you don't, and there's some specific uses that are covered, criticism, commentary, some things like that. But if you want to, for example, sample a music track, there is no fair use internationally and globally. It just doesn't exist. So as you're using works, think about, and if your defense in the United States is fair use, that's probably not going to be available internationally. So that's something to consider. Fair dealing doesn't apply to that. Moral rights are another thing about a work for hire, about who owns the rights in the works. So there's a lot of different overlays on copyright. What I would say, if your takeaways, you don't have to have everything memorized, but what I would say, as we said earlier, the laws outside of the United States on copyright are generally not in alignment within the United States. So if you have works that you need protected, you really ought to make sure that you know what you're talking about in those countries. I've kind of gone on for a long period of time. Uma, you have?
Let me go back to something, a couple of things. One, moral rights. I literally remember speaking about moral rights in a setting. I won't say where, again, not speaking on behalf of any company or individual. And they're sort of like, did we do something wrong? And so moral rights are not understood, even within sort of IP contexts. So you're not alone if you're like, huh, what does that mean? But I think it's important because it is something that is very narrowly, in the US, generally, I think it's only available for visual artists, so, paintings and sculptures and things like that. But internationally, moral rights are a huge deal, particularly, I think, France and Germany. And France and Germany very specifically important to business that we do based on European presence, I'll just say that. But how moral rights are viewed I would just sort of give this caveat. Sometimes we think about them in sort of like the, work for hire context, of course, and other contract, other arrangements and agreements. I see a lot of more rights coming into content releases, employee content releases. So I don't know how many of you have responsibility at your companies or your firms for kind of right of publicity matters. So our team at our company, we also have employee content releases. So like the release of NIL, right? The name, image, likeness, testimonial, all that good stuff sort of comes within the remit of our team. And one of the reasons I bring this up is because moral rights are taken very seriously. Again, outside of the US, probably more, but even in the US, right? Like an artist does want sometimes to get credit for something they created, whether there is any economic value or any ownership that they maintain in the actual copyright, right? So that's the attribution. And then the integrity, right? They don't want they don't want you to use their image, name, likeness and make changes, modifications, and sometimes distortions that can have reputational harm. So just for this team, think about it also in the context of if you are looking at employee releases or talent releases, right? Your companies might hire third-party talent, and you want to use their, again, name, image, likeness, testimonials, voice, et cetera, in a marketing context, think of the moral rights provisions. I think in the US, Mike, correct me if I'm wrong, but I think you can waive the right. I don't think you can transfer, but you can waive the right. So I can say, you know what, you can have my moral right. You can't do that, for example, outside of particularly in Europe, you can't do that, right? So I think somebody can sort of give up their sort of right to enforce, but they can't waive that right. And so something to think about. It just always hits me because a lot of people don't understand moral rights.
Okay, just a couple of thoughts on the copyright section. First, in terms of like reasons to register, one other kind of thought is like, it just adds a level of gravitas to the letter you wrote someone. If you can say that the copyright is registered, and of course it can be a little bit more of like a hammer that you can kind of use in encouraging people to stop, infringing your copyright. I don't think I have anything to add to your comments on moral rights, which was beautiful. And then on fair use, a couple of just high-level thoughts. First of all, like, I don't know, once you're in the realm of fair use, it's like, great. Well, just a reminder, it's a defense, right? I mean, I often hear like folks coming to me like, with no basis or reason, just like, but it's a fair use, it's a fair use, right? What about the First Amendment? And then there's a few things to think about there, which is like, well, the First Amendment is United States specific. So if you have a big team in the US and they're working on something that's a global campaign, something for them to realize, really want to hammer home that notion that the fair use defense is not necessarily going to be helpful to them. And I think that's it. That's all I got.
I think it goes back to a little bit about what Uma was saying, that people understand the vernacular, that moral rights, they're like, well, I'm highly moral. I would never do anything. And it's like, well, okay, I appreciate that. Good for you. I'm sure you go to church on Sunday or your synagogue or wherever your place of worship is. You're highly moral. I get that. But this is different. It's a moral, and the fair use is equally like, you sort of drill down and they're like, well, I think it's a fair use, often with great confidence. And you're like, why do you think it's fair? And ultimately the drill down is, well, I personally think it's fair if I do this. Sort of.
Or the other one is I scraped it from the internet. So it's freely available, right? And so I'm like, no, that's not. So I think you're right. Fair use is often misunderstood. And it's really incumbent on us as IP attorneys to explain to our business clients, and of course your outside counsel explaining what fair use means. It's very fact specific. So don't sort of make your assessment. I always say, let me review the proposed use and let me legally assess. It sounds like it might be to you fair, but it's really a legal assessment. And then, like you said, fair dealing outside of the US, and most countries sort of operate on, the provisions are quite different. And so don't assume just because you can use content in the US under a fair use provision that you can use the same content outside the US. Comes often, Kenny, you'll remember this, like in our music and entertainment days, but a song that I can play in the US, I may not be able to play outside of the US because I might be able to sort of establish fair use rights here and not beyond the U.S. So very important that people understand, and then when they don't, please rely on the experts.
I'm going to give one last, and not to beat copyright to death, but I will just throw out there, one of the things that we used for quite a number of years was copyright as a backdoor trademark registration, because it used to be, and I don't mean to, and it's still potentially available, but if you take a Dasani bottle, Andy Warhol painted, objects that were consumer products. And I don't think anyone would doubt and say that an SOS Brillo box that Andy Warhol painted is subject to copyright. So then, if you have product packaging, it is a combination of design in terms of words and verbiage, and in terms of look and feel. That all is, and for years, the Copyright Office, the old argument was if you took a banana, they would register a banana. Now it gets into a banana now sells for $300,000 at Art Basel in Miami. But in any event, you could register almost anything. So what we would do is we would take, if a client didn't have money for a global filing portfolio and it was a design mark, we would file a copyright on it. Because then we could go under the Berne Convention, and we could go internationally and go after people who were, and in some ways it was really powerful, because you could really go after folks without having the registrations in country by country by country. It gave you a shot. It gave you a reason to go and say, hey, they're infringing it. The reason I say this is it may, and the wheel may turn. There's, who knows what's going on with the Copyright Office these days. But right now, if you file that in the Copyright Office, they will ding it. They will absolutely positively reject it, and they'll say, nope, you ought to go under trademark. And my response is, why can't it be? Mickey Mouse is a work of art and content that is protected under copyright, and Mickey Mouse also serves as a symbol of the Walt Disney Company. So why is it? And we have tried putting it in picture frames. We've tried hanging on the wall with labels and gallery lighting and stuff. We've had a little better shot with that, but I'm just telling you that if you're looking for something to pull out with a client and say, how in the world, we have no budget for international protection, get a copyright registration, see if you can get it. It's a way of at least getting and again, not word marks, but design marks and logos, that sort of thing. So. Okay, let's now go over to clearance, pre-filing, in terms of the importance of that. And one of the things that we wanted to go over a little bit, and we'll do it in this context, is, so we've had the Berne Convention. The Madrid Protocol is another treaty that about 130 countries have signed onto. And so it works similar for people who work in the patent space with PCTs. You file a base home application, you select which countries you want to extend it to, then you have to pay the filing fee associated with that, and then it automatically gets sent within a time period. And Andy may want to talk about this. It's supposed to be sent within a time period, and then it's supposed to be reviewed by a national trademark office, having met certain requirements for that. So that's a very important factor to keep in mind about as you're trying to get global trademark protection is, hey, do we use the Madrid Protocol, and is that something that we that we use, and is that going to be something that we want to try to get protection for that? Yeah, I think, yeah, please. Yeah, I think for both, I would love to get both of your perspectives about how Madrid fits in, how you use it.
No,
what are the caveats with it?
I'd be interested, because I think you guys probably use it more, no. But there's always sort of this struggle between Madrid, for example, and do you just sort of go direct to national trademark offices? And, I think there are benefits to both. I always think, and I probably to leave with you all, like if